Mrs. N. Goswami, the learned counsel for the petitioner, submits that she has instructions from the client, from the petitioner, not to press the instant petition. Accordingly, the instant petition stands closed on withdrawal. Interim order was there? Any interim order was there?
No.
Item number 2 for motion.
Yes.
Lordship, I am appearing for the accountant general. Lordship, we have received telephonic instruction, and as per our instruction, Lordship, the petitioner is entitled for family pension.
Lordship, this is the instruction which we have received.
Where is the learned counsel for the petitioner? There the problem arises. None appears on behalf of the petitioner on call. Mr. D. Rabha, appearing on behalf of the Office of the Accountant General, Sam, submits that the petitioner is entitled to the family pension. Mr. D. Bora, appearing on behalf of the Superintendent of Police, Karbi Anglong District, had submitted that as the PPO bearing number 94840200548 have been sent to the Treasury. The Office of the Superintendent of Police is unable to provide any documents in respect to the petitioner. It has further been mentioned that the petitioner may be informed to apply for duplicate PPO from the AG's office. Further to that, the Superintendent of Police also have stated in a communication issued to the Junior Government Advocate Assam that the petitioner will also be informed in that regard from the state office. The said instructions is kept on record and marked with the letter X. Mr. R. Bapujari, appearing on behalf of the Treasury Officer, further submits that appropriate steps will be taken for the purpose of you are having the PPO with you.
Your Lordship, we don't have the paper.
Can I see my lord to the writ petition? The communication made my lord to the treasury officer. After treasury,
I'm sorry, Lordship, I was in court number 18.
page 18, my lord.
You go to court number 18. Your presence is not required. Yes. So they say that the PPO is with you. So you do whatever is necessary so that she gets the family pension. Because have you seen the instructions?
Your Lordship, I just have one copy.
What is this type of instructions you have? Only one copy.
But it was only, there's only one.
Is this the state of affairs? The Superintendent of Police is in such a shambles. The finance? You are also appearing for the finance department. Why didn't you do something? When the Superintendent of Office of the Superintendent of Police, being the head of the district, is in such shambles.
Lordship will kindly keep this matter pending, my lord. Let me communicate to the treasury. What
No. What is there to keep it pending? The treasury officer shall do the needful in that regard, what is required. And the petitioner shall approach the treasury office.
Yes, that much, my lord.
Last line too. Submits that the petitioner may approach the treasury officer. Which one? Treasury officer, which?
My lord, it is half long.
My bank sub treasury. And the said treasury officer shall also do the needful so that the petitioner receives the family pension. So, taking into account the above submissions, this court therefore disposes of the petition with a direction to the petitioner to approach the treasury officer, my bank sub treasury. The said treasury officer shall do the needful so that the petitioner receives the family pension. This court further directs the superintendent of police, Karbi Anglong district, also to aid to do the needful so that the petitioner receives the family pension. It is made clear that upon the petitioner approaching the treasury officer, the respondent authorities shall take a concerted effort so that the petitioner receives the family pension within 3 months therefrom, with the above petition stands disposed.
At note 3,
Yes, Mr. Burwa.
My lord, here, my submission will be read, my lord. Petitioner is the wife of wonder.
What do you want?
Actually, my lord, there is a dispute regarding this one. Only if
Pension and pensionary benefits may
benefit
not be
to-
released in favor of the petitioner number. After the day. What is this prayer?
no,
Can
here
we come to
date of husband died, husband died. She is entitled for pension, but difficulties has come. When he died, he is in Jorhat hospital. The death certificate was collected by another private lady, private respondent had collected. That is why it's without going on anything, the council appeared filed a title suit. The jurisdictional issue, it's been disposed of. You go to proper forum. Now, question is coming, my lord. Here I am today. Not, I have given sufficient documents before lordship to prove that I'm legal right.
No, first and foremost, tell me. See the page, kindly see page 17 of
Page,
your petition.
page
17. What is your prayer? Tell.
My lord, as to why pension and pensionary benefit may not be released in favor of the petition number 1. As to why cannot be released.
Where?
As to why calling upon the APDC as to show cause as to why pension and pensionary may not be released to in favor of the petitioner. As to may not be released in favor of this one. Next point decision. And then direction may not be issued to the decision. Direction may not be issued to here.
Now what has happened?
Now, my lord, what happened? Then
You are the first wife.
I'm the first wife with
Who
all
is the
the
second wife?
second wife. She has only now by the death certificate only. She's not a second wife. But death certificate one is collected from registrar office by register medical medical college had shown that private lady is a wife. Difficulty is
Where is the private lady?
lady is similar that medical certificate I will place for her.
No,
Yes,
who is the
please.
private lady? Where is the private lady? The party.
But is there? Here, my lord. ये ज्योतिषमय नेउग and श्रीमती शर्मी बड़ा नेउग.
Where is Sarmi Burwan?
शर्मी बड़ा नेउग.
It's 10.
Then that death certificates in her name. That is the only difficulty has come, my lord.
Hmm.
Now I am today only because praying notice may go if that private respondent comes proof before lordship, single document that he sees wife, definitely I'll go to time for civil suit. That is my today's subject. I'll go for civil suit because if she can prove by one is a legal wife, only one document if is shown, that is enough, then I'll submit it before Lordship. I'll myself will submit and I'll go to civil court, if so. But in this regard, I have another affair. I have filed an application before the legal notice was sent to the judicial. They did not take this account on. In other alternatively, your Lordship may dispose of. Otherwise, it is my humble prayer only, Lordship satisfaction only. This one, they will call both the person, me and wife. They will verify records. After verifying, let them give pension a bit, because that legal notice also served. They are also silent. Now I'm leaving to Lordship now because the pension matters. This is because
My lord, I agree with the second part. Let the epidicial authority give a notice to the persons. Because here, my lord, the death certificate, no, he has not annexed anything in the writ petition that he has submitted some kind of documents.
Have you approached the epidicial?
He just said a legal
Yes,
notice has been just
it
said.
was
Where?
filed
At
annexure
page 35, annexure 9.
35 by way of legal notice. It was sent.
Or this one?
My lord.
What have you done with this?
My lord, I have to obtain instruction to what has been done.
Yeah,
It's got the motion today. That's why my lord may dispose of this matter directly in the APDCL to consider the case of the petitioner by giving an opportunity to submit the documents. And because as per the record, there is a photo annexed with the
But you have a particular scheme na, by which you do it. APDCL has a scheme na, asking these people what are the documents and all.
Yes, my lord. There.
What is that scheme? Last time you have stated something to that effect, I remember.
Yes, my.
Yes. What is that?
My lord, that
You
is for
make
the,
inquiry, na?
yes, my. We can make a query. So my lord may just direct us to remand the matter back, and we can after that we have a held inquiry, and thereafter we will release a pension to the petitioner, my lord. That can be done.
You release to the person who is entitled.
Yes, we release to in person.
Why do you want to release to the
No,
person?
who is entitled? That's what I meant.
When you never said that.
I apologize.
Mr. C. Purva, the learned counsel appearing on behalf of the petitioner. Mr. S.P. Sharma appears on behalf of the respondent number 1, 2, 3, 4, 5, 6, 7, 6.
Six,
You are
seven, up to 6 million.
Mr. D.P. Bora appears for respondent number 7, State Bank, not there. Okay.
No.
Taking
Seven.
into account the order which this court proposes to pass in the instant proceeding, the presence of the respondent number 8, 9, and 10 are not required. The instant petition has been filed by the petitioner claiming to be the wife of late Nabojiti Neog.
No, my lord.
To claim has been filed by the petitioners claiming to be the wife and son of late Nabojiti Neog. It has been alleged that the respondent number 9 and 10, however, has no relation whatsoever. So he is the son. You admit it.
Now we have.
No. In your petition, you have admitted son.
No, that is a dare showing this one.
Now you have also on
No.
affidavit stated.
No, whatever document is, I cannot.
No, but are you not admitting it?
No,
As number
yes.
9.
No.
No. So kindly see page 6.
No, they are claiming, man.
No,
Claiming.
Claiming you should
Yeah,
have
this
said
is-
purported or alleged, whatever may be.
No,
You are
because-
saying son of late.
No, because of death certificate. Claiming is because of death certificate. I'm
Mr. Borua, on the other hand, when it comes to number 10, you say care of. See,
Then
number
wife.
10, you say care of. Why have you put number 9 as son of?
this, I will take little.
Admitted that they are the son and the other three. Whereas on the other hand, the respondent number 9 and 10 are illegally claiming to be the son and wife, respectively, of late Nabojiti Neog. These aspects, Mr. Sharma, SP Sharma, the learned counsel appearing on behalf of the respondent number 1 to 6 submits that there is a mechanism available with the said respondent authorities whereby they are in a position to issue notice to the respective claimants, and thereupon, on the basis of the available materials, can pass appropriate orders as regards the entitlement.
Well,
Taking into account that the issue involved herein would require an adjudication of facts, which this court under Article 2 to 6 is not in a position to do so. This court, in the interest of justice, directs the respondent number 1 to 6 to issue notice to both the petitioner as well as the respondent number 9 and 10, and thereupon decide as to who would be entitled for the pension and pensionary benefits of late Nobojiti Neo.
Right.
With the above, the petition stands disposed.
only time limit, yeah, some time will be time date. That's what it was.
They know it.
No,
Taking into account that it is a case of pension and pensionary benefits, the respondent number 1 to 6 shall take the said make the said adjudication as per at its earliest convenience.
Right.
Notice has not been issued, so how can it happen? I can fix a time.
Item 4.
well,
May it be the lordships.
Hmm.
The petitioner's wife has been expired on 17/9/2008 while servicing a headmistress of Uttar Barakapara Dakhin Miss Punya High School, district of Paksa, your lordship.
Hmm?
After the death of his wife, your lordship, as he is nominee, he has submitted all his wife's pensionary documents to the respective authorities, your lordships.
And you have not got your pension.
My wife, yes, God. From since 2015 onwards, no communication has been made to me. Either
There is a PPO.
PPO, there is a PPO and
Then why haven't you received?
lordship.
Did your wife get pension?
No. After the,
Then why is this PPO issue?
there is a defect has been occurred, your lordship.
Pension, family pension proposal in respect of so and so. With the above, the incumbent expired on demand, but pension proposal submitted for hand is required as per rule 205. Oh,
And that defect has been rectified, your lordship.
which department?
It's a education department, your lordship.
Mr. Rava,
Yes, my lord,
you are the person to be blamed.
my lord, please kindly come to page 17, my lord, annexure 3.
Yes.
It appears, my lord, there has been some inconsistency, my lord,
Of what?
in preparing the
That is what
proposal.
you are to be blamed.
Yes, my lord.
Because of your delay, there is a requirement of this approval of 205 and 206.
Lord, I'll have to take instructions. What has caused this?
No, for that, we will put those people to task
My lord,
by imposing interest on them, because there will be interest.
yes, my lord.
Heard, Mr.
H. Borwala.
So and so the learned counsel appearing on behalf of the petitioner. Mr. S.R. Abha appears on behalf of
My lord.
respondent numbers
6 to 9, my lord.
6 to 9. Mr. J.K. Goswami appears for respondent number 2. Who appears for? Yes. Mr. P.K. Bora appears for respondent number 1, 3, 4. And who appears for 5?
No, lordship, me, 2 and 5.
2 and 5. Okay, issue notice. And Mr. Arbo Pujari appears for respondent number 7. 3 and 7. 3 and 7. Issue notice making it returnable on 7th of August 2023. As the respondents are duly represented, extra copies of the writ petition be given during the course of the day. The case of the petitioner herein is that petitioner's wife was working as a
Administrators of Dakshin Uttar
Then teacher.
no, the petitioner's wife retired as the headmistress of Uttar Barkopa Dakshin Punia LP School, Baksa. When?
she is expired during her service, Your Lordship.
Huh?
During her service in 79
retired.
2008,
So she has not retired.
not retired. 79 2008.
No, yeah, well. The case of the petitioner herein is that the petitioner's wife, while working as the headmistress of Uttar Barkopa Dakshin Punia LP School, expired on 17/9/2008, leaving behind the petitioner and 3 children. The petitioner claims to be entitled to the family pension. The learned counsel for the petitioner has drawn the attention of this court to the communication dated 4/6/2013 issued by the Director of Education BTC Kokrajhar, whereby the original service book and pension papers, which was received from the Inspector of Schools BTC, was sent for finalization to the Director of Pension Assam. It further reveals that the Finance and Accounts Officer, after a passage of another 2 years, that is on 26/2/2015, issued a communication to the Deputy Inspector of Schools Kokrajhar stating inter alia that as the wife of the petitioner expired on 17/9/2008, but the pension proposal was submitted on 4/6/2013. Hence, PPG department approval was required as per Rule 205 and 206 of the Assam Service Pension Rules 1969. It was further mentioned that upon submission of the new pension proposal, steps would be new pension proposal, steps would be taken. Steps should be taken to see that the deficiency does not reoccur again, leading to return of pension proposal. It is the further case of the petitioner that thereupon also nothing has happened, for which the petitioner had submitted a representation on 3/3/2023 for the pension of the petitioner, for the family pension. However, the respondent authorities, having not taken any steps, the instant writ petition has been filed. The respondent authorities, more particularly the authorities in the respondents in the BTC, as well as the Director of Pension, is directed to apprise this court on the next date as to why there has been such a why there has been delay in sending the pension proposal, family pension proposal of the petitioner, as well as also to the director of pension, and as to why the director of pension took a further 2 years to return the said pension proposal again to the deputy inspector of schools, Kokrajhar. This court further directs the counsel to appear representing the deputy counsel, the respondent, that is the deputy inspector of schools, Kokrajhar, as to why steps were not taken thereupon and what steps have been taken thereupon. Pursuant to the communication dated 26/2/2015 by the Director of Pension, from the Office of the Director of Pension. This court further puts the respondent authorities, more particularly the officials of the Director of Pension, the officials of the BTC, as to why interest upon the delayed payment of family pension should not be recovered from their salaries. Interest upon the delayed payment of family pension should not be recovered from their respective salaries. List according. You have to file affidavits, both of you. Mr. Goswami, affidavits. The said respondents shall put it on by way of affidavit, the above mentioned queries. The pendency of the instant writ petition, pending notice, it shall not be a bar upon the respondents to act and pay the family pension to the petitioner. We'll get it, don't worry. 5. Yes, Mr. Mazumdar,
My lord, here
you are on the other side.
child care leave, my lord. Lordship will find I had the petitioner had joined the services in the year 2004 as a constable.
Hmm.
Now, in the year 2022, my lord, September, she was granted promotions to the rank of head constable. Lordship will find at page 17.
Hmm.
My lord, I was being posted to a left-wing extremist area. I have 2 children, my lord, a daughter and a son who are studying at class 3 and class 8 at the present.
Hmm.
On my request, my lord, Lordship will find at page 19, page 18, my lord, I'm sorry. In September 2022, my application was forwarded because I was retained at Group Center, Guwahati, till 31st of March 2023.
Hmm.
This is informed to me. Lordship will kindly find at page 21A, annexure 4. I am the second
What is the
person.
age of your children?
My lord, they are in class 3 and
3
class
and
8. My lord.
7.
One is 7 years, one is 12 years.
One is 7 years
7
and
and
12.
one is 12 years. Now, my lord, when they retain me, Lordship will find at page 20.
You are challenging which order?
But I'm not challenging. What has happened is, my lord, when they want to relieve me, I told them that extend my stay for another year, I won't take care of my children. They rejected my extension on the ground that I should have 2 years of mandatory field service for my next promotion. That is the ground of rejection. It is on record. Immediately, I moved an application saying that my children are studying, grant me the childcare leave of 450 days with earned leave of another 60 days, total 510 days. I am ready to go and join. This application is given on 8th of June 2023. Now, my lord, they want to relieve me without granting me the childcare leave to go and join at left-wing extremist area at Bengal. My instructions from the client are the leave being granted. On expiry of the leave, I'm ready to go and serve there because I can now carry my children there and get them admitted somewhere.
Where?
Just at West Bengal, wherever they have posted.
Where they have posted?
My lord, Midnapur, it's called, my lord, near West Bengal and Orissa border. It's a left-wing extremist area. And my children are studying here in a private school. Had they been a Kendriya Vidyalaya, the transfer would have been possible. At this midterm, I cannot transfer. So I want to take my childcare leave, get their session completed, admitted in a school in West Bengal, start their session, join my duty. That is why I want
Those
my
children will study in Calcutta.
Wherever it is possible, even someplace near where I can keep my family out, because my husband is also serving and he is serving in another location in another left-wing extremist area. I cannot keep my children with him also for the time being. So, my lord, my childcare, my lord, this honorable court and other honorable courts have been held that childcare, my lord, when I want to avail the leave, when it is best for my children, it is for me to decide. The only reason for them not giving me an extension is I have to complete 2 years mandatory field service for my next promotion. It is because of me, not because of their service experiences. Allowing me to leave at this stage, my lord, and not taking an action on my prayer for the application and trying to relieve me to my place of posting along with my children. It's going to take havoc for me. Let them consider my application, grant me my leave. I give an undertaking, I join at my place of posting on the expiry of leave. They propose to my lord relieve me today or on Monday.
You join there
But that
and
is the-
take the leave.
but that is the difficulty.
Why?
But the difficulty lies here. My children are studying here. My husband is not here. He's
No,
not
what is
relocate.
the problem? You go there,
I cannot-
join there.
I
No, no, you join there, take the leave.
My lord, I cannot break my children's study course here to take them there.
Don't there. It's not
My
required.
lord, where do I keep my
You
children?
take your leave from there.
My lord, where do I keep my children for the time being? Where do I keep my children for the time being, my lord?
You go there, join and then take the leave.
My lord, the children remain here.
Yes,
My lord,
Lordship.
Well, the
That is
children
my
will
instruction.
remain here. You also remain here.
my lord, no,
We
no, that
happy
leave
with the
period-
510
going-
days.
my lord, going and joining. If my leave is not granted there for some reason that you have just joined, I am not granting you the leave. It will be another problem for me. I will not be allowed to come back to my children here. I have to attend my duties there. Everything goes, my lord. Childcare leave, my lord, this honorable court has held. The childcare leave, it is for the mother to decide when to avail that leave. And it is being beneficial. They have to consider that first.
No, no, consider is one thing, giving you is another.
My lord, right? Leave is never a matter of fact. I concede.
Then
But so far as childcare leave is concerned, since I'm still under their jurisdiction, granting me the leave here is not going to change anything for them.
no, no,
Only
you
reason
go.
I'm not being
You,
retained,
you see, I am not going to pass any interim order here.
but what I would
You
say-
do whatever you, I only pass a issue and notice to that. You go there, join and take the leave, whatever leave.
Madam, that leave I have already applied here. That
Very
leave
well.
is on.
Again
That
apply.
leave application is on.
Yes, madam, what do you
8th of
say?
June I have applied.
Lordship, my instruction is that let her join there and she could place her case there, Lordship. The commandant CCL is her right, Lordship. She'll definitely get that from that her new place of posting, Lordship.
My application here on the 8th of June.
And once we
2023,
had
before-
already
before they
given
take a
her
decision.
extension for 6 months, we have already given.
Huh?
Last year, 22 September, she was promoted and transferred. Then she was here till today. She is here, Lordship.
And you have only 6 months only that can be done.
Yes, Lordship. And
Because
she knew
that day I saw some of your, something I have
No,
seen. it.
extensions
And
are
she knew
for-
You were appear, no, in that case, some transfer, I asked you, then the matter
Yes,
came up
Lordship,
before
yes.
Justice Shyam. Those matters, those three
No,
motions
not,
which you
not
have
in
made.
that case, but yes, in that case also, Lordship, it was disposed of by giving only some joining time.
Mm.
Here, Lordship, she knew that after 31st of March, she had to make arrangement, Lordship. Till 31st, because her children's school was there, Lordship, to finish her academic year, Lordship. My instruction is she could join there and ask for her leave, Lordship.
Lordship may kindly have page 21A for a moment. It is on 17th of April, they tell me that your extension is coming to and you will be released.
You knew it when you asked for
But at
extension.
17-4 they tell me. They did not release me. 17-4 Lordship will find.
No. When were you promoted?
When I was promoted, I immediately applied to be extended. They didn't release me. They did not tell me anything. There is nothing on record to say that I am extended. I did not know. I stayed.
Then how did you stay?
They did not relieve me. I continued. That is how they do it, my lord. Lordship will kindly find at page 21A.
Yes, where is your appointment, the promotion order?
Promotion
Annex
order
of
Lordship will find at page
17.
17, my lord.
Yes.
Her serial number is 11, Lordship.
Mm.
At page
Lima
17,
Eka.
type copy. I'm at serial number 11.
Allotted, posted to 232
232
M
Battalion.
battalion. Okay, then
Then, my lord, at page 18, Lordship will find serial number 2 down below, my lord.
you want a stay of this. We can stay
No.
this 7/9/2022. Let me stay that.
The entire promotion, everything.
Yes. You are happy. Don't take the promotional order.
My lord, I will join on promotion on.
She is availing it already.
Yes, my lord, I would agree to that.
Huh?
I would agree to that. Let him grant me the leave. Let me be with my children.
No.
That's
The
7/9.
promotional order, you don't want to take the promotion.
I will get my promotion only when I join.
No. This promotion, you don't want the promotion.
My lord, If that is for my children,
No, I am asking you.
she will give me 5 minutes, I'll just have a talk with
You
her.
don't take the promotion.
I'll do that for the next.
You're okay.
She's appealing already from 7/9/22
No,
lordship.
she's
She's
not.
getting her salary,
No,
Yes,
higher salary.
yes, yes.
Yes.
From 7/9.
And if she is getting her higher salary, that will amount to recovery. Huh? You take your instructions.
100%.
We'll take it up at 2. You also take whether the salary has been
Yes.
taken. If it is so, that will be subject to recovery.
Outline.
I'll have a-
6,
Yes.
It is regarding non-payment of gratuity of provisional fund and leave encashment. On a petitioner husband was compulsory retired from United Bank of India
Hmm.
in on 26/3/2020. He has joined and expired on 17/9/2008.
Hmm.
Thereafter, the United Bank of India on 11/10/2020 asked for certain document from the petitioner to exhaust loan. Loan amount has not been disclosed till date. What is the loan amount? I got the pension, not for.
Are you entitled to pension?
Yes,
When did you retire?
I
2001.
retired 26/3/2001.
What are you doing for last 22 years?
My lord,
Are you alive?
correspondence are going on, my lord.
Understood. But on the basis of correspondence, can you just keep on extending like that?
Actually, that bank was taken over by the Punjab National Bank.
That was only 2 years back.
Yes, my lord.
Yeah.
And here.
What is your explanation?
Ex-
Why you have approached after such a long time?
2008
No,
Yes.
2001 you have retired.
retired and
Then why have you
I
approached
am not
now?
my petitioner husband, my lord. Husband.
What?
A petitioner husband expired on 2008 without getting any pension. Then I approached the authority, United Bank of India.
And your husband did not approach.
From 2005, Lordship kindly see page 7. United Bank Staff Pension Department of Kolkata by letter dated 19/1/2005 addressed to receive regional manager United Bank and Shifter.
You retired, terminated, or what?
Compulsory retired.
Compulsorily retired. Why?
Some,
Why?
Some department proceeding was there.
Now, departmental proceeding, what happened?
That resulted to compulsory retirement.
Why?
There's not been the petitioner husband, my lord.
Have you brought on record that?
Yes.
Where?
No, I have not brought that.
Then? Yes, Mr. Doctor.
There is a charge of financial irregularity.
There the problem arises. And there you must be having that clause
Yes,
that we don't pay
my lord.
to those people where there is a financial irregularity.
Yes.
And officer and staff.
Now that may be, my lord, one thing your lordship may see is the award staff. Therefore, my lord, even if there is a punishment, possibly, my lord, he is entitled to gratuity.
He has got the gratuity, no.
I don't know, my lord, it's not very clearly written anything here. And my lord, unless there is a clear instruction with a degree of certainty, I cannot tell all this thing. The lordship may issue notice for the time being. In the meantime, we can file our affidavit.
Keeping the
And-
maintainability of the reputation
yes,
open.
And in the mean, they have received 6,58,000, my lord,
As gratuity.
as
Not pension.
pension, my lord.
He has got his pension.
Yes,
Yes,
yes.
but
Then what are you asking for?
staff provisional fund, gratuity, and leave encashment.
No, you also asked for pension, some part
Pencil
of
payment
pension.
order was not there.
Huh?
Pencil payment order was not. Directly it has
To
been.
grant interest on the area of pension granted. That is 6 so and so at 12%.
Now they want interest on that.
And
When did you get that amount? 6,54,000.
in 2022. 2/3/2022, and recovery was There are 2,88,742.
From?
Recovery was there.
On account of bank loan.
Bank
Housing
loan.
loan.
That bank loan has not been disclosed for what loan was there.
Heard, Mr.
AMF.
A. Ahmed, the learned counsel for the petitioner. Mr. S. Doctor, the learned senior counsel. It's SCC Doctor, the learned senior counsel, assisted by Mr. S. Doctor, appears on behalf of the respondent number 2, 3, 4, 5, and 6. Miss
One.
So appears for respondent number 1.
Okay.
Issue notice making it returnable on 21st of August 2023. So as the respondents are duly represented, extra copies of the writ petition be served upon them today during the course of the day. The case of the petitioner herein is that the husband of the petitioner retired on 25/3/2000, was compulsorily retired
Yes.
on 2001. Thereupon, the husband of the petitioner was entitled to the pension and other benefits which have not been granted to the petitioner, to the husband of the petitioner. Eventually, the petitioner's husband expired on 17/9/2008. The petitioner, after persistently approaching the respondent banks, was paid the amount of rupees 6,54,900.06. When did you get that?
22. 20. 02/3/2022.
So and so. On account of the delay so caused in making the payment, the petitioner claims to be entitled to interest at the rate of 12% with effect from 26/3/2001 to 2/3/2022. The petitioner's further case is that an amount of rupees 2,88,742 have been recovered from the bank account of the petitioner. Full stop. The petitioner therefore seeks for a direction for refund of the said amount, along with interest at the rate of 12% with effect from 2/3/2022. The respondents, more particularly the respondent number 2 to 6, is therefore directed to file an affidavit on or before 14th of August 2023. The petitioner, if so advised, may file a reply on or before the next date.
Publish.
7.
Your Lordship may kindly pass over the matter for time being.
Bye.
Mr. Dilip Muzumdar, additional AG, he is handling this matter. He is on legs in the court, Your Lordship.
We may not require him also. And if we require him, if you think Mr. Dilip Muzumdar has to appear, then he may appear on the next date of notice. Yes, Mr.
Lordship, my lord, that copy of the petition is not served to us, Lordship.
Has been served to you.
No, Lord. And even our name not been reflected in the list.
You are who?
I'm order IGR, Lordship.
Okay, let us first see what is his case. Yes, what is your case?
My lord, I am a duly licensed, my lord, Muslim marriage and divorce registrar in the, my lord, jurisdiction of the Nilam Bazar police station. My duty, my lord, as per the 1935 Act, my lord, is to register Muslim marriages. My lordship is well aware, my lord, in the year 2010, by amending the Muslim Marriage Registration Act of 1935, my lord, the Muslim marriages in our state has been made compulsorily registerable. Now, my lord, in the Registration Act of 1935, provision has also been made for the purpose of registration of the marriages of Muslim minors, bride and groom. Now, my lord, they are saying Sorry, my lord. Now they are saying that as there is a bar under the Prohibition of the Child Marriages Act of 2006, as this is a, my lord, criminal offense. So therefore, my lord, I have breached that law, and for which, my lord, my license had been suspended. Another proceeding is also pending, my lord, before this honorable court. My lord, regarding the proceeding which had been instituted against me, I have challenged that proceeding, my lord, on the same context. They have initiated another proceeding, my lord, that why the Muslim minor marriages is registered by me. That is the question they have asked. My lord, I have replied and I have responded to the proceeding also that as there is no bar in the 1935 Act, I have not committed any offense. If for a moment, my lord, if I may be permitted to draw my lordship's attention to the 1935 Act, my lord, it will clarify the entire thing, my lord. My lord, the
You are challenging the suspension order.
suspension order, my lord. This is in violation of this honorable court's order as well as the 1935 Act, my lord. My lord, may directly can come to page number 50 of this manual, my lord.
Page.
Page 50, my lord. My lord, page 50, and the, my lord, relevant part is section 3 at page 52, my lord. May I read, my lord? State government may grant license to register. The state government may grant a license to any person being a Muslim, authorizing him to register Muslim marriages and divorce which have been effected within the certain specified limits on application being made for the such registration, and may revoke or suspend such licenses. My lord. They have the power, my lord. Provided that not more than 2 persons shall be licensed to exercise the same jurisdiction within the same limit, and provided further that when 2 persons are so licensed to act within the same limit, the one shall be a member of the Sunni and the other of the Shia sect. Now, my lord, this after this license, my lord, how the registration is required to be made, my lord, that has also been reflected in section 8, my lord. Applications by whom to be made. Every application for registration under this act shall be made to the Muslim registrar orally as follows. If the application be for the registration of a marriage by the parties to the marriage jointly, provided that if the bridegroom or the bride or both be minors, application shall be made on their behalf by the respective lawful guardian, and provided further that this is relevant, my lord. And now, my lord, kindly see section 9, my lord. On application being made to a Muslim registrar for registration under this act of a marriage or divorce within 1 month of marriage or divorce being effected and not otherwise, and on payment of him of a fee prescribed as per the schedule 4 to this act, the Muslim registrar shall A, satisfy himself whether or not the such marriage or divorce was effected by the person or person by whom it is to be represented to have been effected. Satisfy himself to the identity of the person appearing before him and alleging that the marriage or divorce has been effected. In the case of any person appearing as a representative, these are the, my lord, duties has been assigned. Now, my lord has already found that there is a, if the my lord, bridegroom or the bride is minor, then their lawful guardian is required to be examined, which I have done, my lord. So now this is followed by the another provision of the rule. I beg to draw my lordship's kind attention to the rule 24, my lord. My lord, rule 26 at page 73, my lord. Procedure before registration. The Muslim registrar shall satisfy himself.
So in short, Mr. Bhuya,
My lord.
your case is
My lord,
that section 8 read with rule 26
my lord,
postulates that there can be a marriage of a minor which can be registered.
my lord,
And you having done so,
my lord. I have not.
the proceedings initiated against you
My lord,
is illegal.
is illegal. That is my case.
Where is Mr. T. Majumdar?
After some time, he's on late.
Okay. We take after some time.
My lord, my
And
lord.
what is the interim order passed by this court?
My
There is
lord,
another
yes,
order,
yes,
therefore,
madam, there is
insofar
another
as
proceeding, my
Muslim
lord,
marriage Qazi is concerned, the
No
court
course of
finds
action
that
has
if
been filed.
exercise of it done under 26 here, the same being within the vested, the question arises as to whether
My lord,
Qazi could be held for abatement.
issues have been framed.
Another question may arise in this as to whether the rigors of Porto would prevail. This is for what? Bail?
No, no, my lord, this is for another writ petition I have moved, my lord, challenging the notice at page 43, my lord. And this honorable court has framed these issues, my lord, and this is pending for adjudication. And during the pendency of the
This is what notice? Notice
notice
is
of, my
when
lord,
for-
at page 43, my lord, of this writ petition. This honorable court has already directed, my lord, no.
What is this Prohibition of Child Marriage Act 2006?
My lord, that the, my lordship is well aware, my lord, the government has now recently acted upon that those.
No. Where is that act?
Yes, yes, my lord, this act is here, my lord. Section 9, 10, and 11 is the punishing offense, my lord, towards solemnizing.
Yes.
My lord, section 9, 10, and 11, my lord, if my lord may be pleased to peruse, my lord. Punishment for male adult marrying a child. But no provision is there, my lord, 9, 10, and 11, that if person is registering is amounts to solemnizing, abetting, or something like that.
This is a state act
No, my lord, this is a central legislation.
and the earlier one?
Central legislation. Earlier one is a state act. The Assam Muslim Marriage and Divorce Registration Act of
And there was an amendment made in 2013
2013, my lord.
after this.
Yes, yes, my lord.
And rule section 8 was inserted when?
My lord, it is of 1935, my lord.
No, section 8 was 35.
My lord.
What was the amendment made in
Amendment
2000?
made, my lord. Earlier it was voluntary, my lord. Now, after the amendment, it has made compulsory that all Muslims should register their marriages compulsorily, my lord.
Okay.
And the word Muslim has been substituted with Muslim, my lord. Earlier it was Muslim, M-O, now it is M-U, my lord.
And when was it appointed in for Assam? This act?
My lord, this act came into force, my lord, in the year 1935, my
No. This prohibition of child marriage. Act.
prohibition of child marriage for the entire country. It has been, my lord, on 10th of January 2007, my lord. The very heading, my lord, may be pleased to find an act to provide for the prohibition and solemnization of the child marriage for matters connected therewith.
Where?
My lord, I am finding it in here, my lord. In the
An
text
act.
of-
No.
My lord.
You see, 1.3 says it shall come into force
Yes,
on
sir.
such date as the central government may by notification in the
Notification.
official gazette appoint,
Yes, yes.
and different dates may be appointed for different
Different
states.
state, my lord. That is, my lord, my respected friends from the state can apprise, my lord.
Huh?
Lord, it is not within my knowledge, my lord.
Hmm. So in fact,
My lord.
it shall extend to the whole of India and it applies to all, but there has to be specific official notification to the
Yes,
effect.
yes. May by notification in the official gazette appoint and different dates, different state.
But Mr. Bhuya,
My lord.
why section 11 won't come?
My lord,
And
section
apply to you?
11, my lord, section 11 of the Child Marriage Act, my lord. Yes, yes, my lord. May I read, my lord? Where a child contracts a child marriage, any person having charge of the child, whether as a parent or guardian or any other person or in any other capacity, lawful or unlawful, including any member of an organization or association of person who does any act to promote the marriage or permit it to be solemnized or negligent.
There permits it to be
My
solemnized.
lord, after the solemnization, my role come, my lord. My lordship is well aware, my lord, when a Muslim nikah is solemnized, my lord. After the nikah on the registration can be done. My lord, the government of Assam has also prescribed a Form A and Form B in this act, my lord.
And see,
My lord.
permits it to be solemnized
No, I am-
or negligently fails to prevent it from being solemnized,
My lord.
including attending or participating in a child.
No, I am not participating in a child marriage. My lord may kindly appreciate, my lord. Until and unless the marriage religious solemnization part is over, my lord, there is no provision for registration in the prescribed form, my lord.
Where is that form for
My
me?
lord, my lord, yes, my lord. My lord may be pleased to find the form part starts at, my lord, page 59.
Huh?
Page 59 of this manual, my lord.
59.
My lord, this is the schedule 1, section 6 and 10, form A, book 1, register of marriage. Consecutive number, name of the bridegroom and date of his father, name of the bride, whether the bride is a so and so, name of guardian, date of marriage.
This is the form,
Form for registration, my lord.
the
That
book 1 and book 2.
My lord, may kindly
No,
note-
no. What about this form of affidavit, form of declaration? That's different, no?
No, that is a different thing, my lord. Form B is a talak form, my lord. Form A is for registration of marriages, my lord. And my lord, may kindly note clause 9, date of marriage. This marriage part is required to be over, my lord.
What?
My lord.
Why date of marriage? The marriage part has to be over.
No, my lord. Until my lord may again peruse the section 8 and section 9. Read with section 11, my lord. The religious part, my lord, I have personally inquired into the qazis or the my lord person who is registering. Their duty is only to register the marriage, my lord. The religious part or solemnization, that is Kabul or the Kabul Nama, my lord, bride, both from the bridegroom and the bride is required to be over. They are required to be husband and wife religiously and legally. Then only, my lord, they can make a presentation before the Muslim marriage register that our marriage is over and now you kindly register it. My lord, otherwise I am helping the government.
Now,
my lord.
are you saying
My lord. My lord.
that without a formal nikah, there
Yes.
cannot be a
There
registration?
cannot be a registration. my lord.
Where is it?
No,
In
my
the
lord,
act?
that is the purport of the law, my lord. That is the purport of
No,
the
no.
law.
Where is it in the act that after the nikah this can happen?
My lord, my lord.
Because otherwise, what will happen? The same principle. Why won't it apply in the case of Hindus? Because in Hindu, the marriage may happen. There's a social marriage by which all this, whatever may be. But a registration can happen and has many cases registration happened prior to that also. Are you saying that the registration would become bad if there is no marriage prior to that?
Yes, yes, my lord. The registration will not have. They cannot do the registration, my lord.
That is too far-fetched.
No, 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 my lord. That is the.
Where is it in that act that
My lord,
after the marriage the registration can happen? Show me that.
Without the marriage, registration cannot be, my lord. Yes, my lord.
Yes, very.
Page, my lord, 1950 law. My lord, this section 8. every application for
Page,
registration,
page.
page 53, I am referring section 8, my lord, again.
Yes.
Every
63.
application for registration under this act shall be made to the Muslim registrar orally as follows.
Ah.
If the application be for the registration of a marriage by the parties to the marriage jointly, provided that if the bridegroom or bride or both be minors, application shall be made on their behalf by their respective lawful guardian.
Hmm.
And provided further that if the bride be for the, this is not required, my lord. If the application for the, this is the part, my lord.
So where is it mentioned that it has to be followed by the registration can only happen after the year? It can be happen before that also.
There is not a single incident, my lord, in our state, my lord, that the registration is done only after the marriage, my lord.
How can you say that?
My lord, I can file an affidavit to that effect also, my lord, to satisfy my lord.
How can you do that? That is
No, no,
wouldn't that be too far? It wouldn't be a difficult thing. How can you say from your
No, no,
personal
No, no,
knowledge?
I am not saying from my personal knowledge, my lord. It is from the, my lord, source collected from the various qazis or the Muslim marriage registrar, my lord.
Hmm.
They have an association, my lord, and I have also consulted with the president of that association that in what manner this registration is done. Now, my lord, they have said that before the registration, there have to be husband and wife religiously.
Where?
No, that is.
No, if they make a law which is
My-
not there in the act
my
and
lord,
you want to take the benefit of the act,
my lord.
then how do I help you?
No, my lord, this is the purport of the act, my lord. My lord,
Where is the purport? Show me anything that there has to be
My
a
lord.
marriage before that.
But my lord, in my
Yeah.
case, my lord, the all registration has been done after solemnization of the marriage as well. And there is no role on my part that my lord, I was involved in this solemnization part. So therefore, my lord, section 9, 10, and 11 is not applicable to me
So-
also, my lord.
Why after 2013
My lord,
the registration is required?
after 2013, my lord.
Why registration is?
No, registration is required because, my lord, it is the, no, it is not like that, my lord. Some person may approach for registration, some may not.
No. Why? You said
My
after 2013 it has become compulsory.
It has become compulsory. my lord.
So a recognition of a marriage
My lord.
in legal sense has to be registered.
Yes, yes,
So shouldn't that registration be a part of the marriage?
yes, yes.
Then if that be so, then are you not involved?
No, my lord, I am not involved, my lord, because I am not solemnizing the marriage, my lord. And it is the statutorily assigned duty. My lord may kindly appreciate that if this provision is not there, my lord, in section 8, they have specifically said, state of, my lord, with my limited understanding, my lord, what I respectfully beg to submit before my lord, that the state of Assam is otherwise recognizing and allowing the marriages of the Muslim minors.
Hmm.
Kindly see the language, my lord.
Hmm.
Kindly see the language, provided that if the bridegroom or the bride or both be minors. This, here comes the my lord, state recognition, or both be minors. This is a law made in the year 19.
No. Why the problem? Why this has happened? That
My
is why I specifically asked you what was the amendment of 2013.
My lord,
If the 2013 amendment is only limited
only limited.
to compulsory, then it does not touch on section 8.
It does not touch me.
But section 8, it gets touched in view of the subsequent law. That is the problem which I am saying.
No, that is law, my lord. The law they have made by a Child Marriage Prohibition Act of 2006. Now, my lord, this law is also applicable in our state of Assam. It has not been recalled, reviewed, or the government has the power to amend this law also, my lord.
Now,
And they have not
marriage and divorce,
My lord.
wouldn't marriage and divorce and all this thing,
My lord.
isn't that in the the third list 3?
Yes, yes, my lord.
So wouldn't Article 254 have consequences on this?
Lord, the law of registration, my lord, the law of registration is, my lord, the central government can also make a law, and the state of Assam is also empowered to make a law. Now, the central government, my lord, as per my knowledge, till date has not invoked that list and make a law of registration. My lord,
No, not the question of registration, on the prohibition.
no, prohibition for marriages, my lord, not for registration, my lord.
Now, if it is a case of prohibition
My lord,
of marriages,
My lord.
child marriages,
my lord.
which is done in 2006,
Exactly. my lord.
then under such circumstances, wouldn't that law override the 35 Act?
No, my lord, because the law of marriage prohibition is that, my lord, with all respect, my lord, with my
Mm.
limited knowledge, my lord, what I am submitting,
Mm.
the law of marriage.
Mm.
Yes, central government has made a law of marriage, but they have not made a law of registration, my lord, till date.
My lord, may kindly verify the part of the registration
No.
of the marriages,
Let us understand
My lord.
that this act otherwise is proper.
proper,
There's no
lord.
problem with that.
my lord,
But if there is a prohibition
my lord,
of having a child marriage,
my lord.
wouldn't
Prohibition-
that aspect
My lord.
override Section 8 to that extent?
No, my lord, with my limited understanding, my lord, it has not override, because if the central government make a law for registration wherein it has been said that the no child marriage can be registered in the entire country or particularly in the state of Assam, that part there is no law as regards till date, my lord. Only in our state, my lord, that has also find place in a Supreme Court judgment, my lord, in Shima versus Aswani Kumar, my lord. My lordship is well aware, where the Supreme Court has directed to make law for the entire country to register the marriages of all religions. Now, when this law, when the judgment was considered, my lord, then this 1935 Act also find place in that judgment, my lord, that there is already a law in the state of Assam for the purpose of registration of the Muslim marriages. My lord. Now, the till date, my lord, central or the parliament has not made any law for the purpose of registration of the marriages in the country, my lord. Now, this law governing in our state from the 1935 till date, my lord, the government of the state of Assam, my lord, could have come up with amendment. If they are so conscious, my lord, restraining the registration of the child marriages, they have not done amendment to this law, my lord. So that's why, my lord, this field of registration has been left open. There is no bar they have imposed me. With my limited understanding, I am respectfully submitting, my lord. That's why, my lord, I have not committed any mistake while discharging my duties. Now, my lord, may kindly see the impugn order is at page 50 of my writ petition. My lord. Page 50, my lord. Peruse the inquiry report submitted by the Deputy Commissioner Karimganj, file letter number so and so, in accordance with the power conferred by Rule 8 of the Assam Muslim Marriage and Divorce Registration is hereby placed under suspension with immediate effect for registration of child marriages by him violating the provision of the Child Marriages Act 2006. On the one hand, my lord, they have said you are licensed, you register the marriages as well as the Muslim marriages. And on the other hand, they have said that I have violated the Child Marriage Act. Secondly, my lord, as this honorable court has already directed that no coercive action should be taken, as the issues has been already, my lordship has gone through, that the issues is framed and it is under the, my lord, at the stage of hearing. At least, my lord, they could have waited till the date of hearing, my lord. If I have committed any fault, they could have taken action against me, my lord. This is, they are also trying to override this honorable court interim direction, my lord.
Where is the inquiry report?
My lord, that report they have not furnished to me. I have come to know only from this, my lord, suspension order, my lord. No, my lord, report has been submitted. No so-called notice has been issued to me that this is the finding of the inquiry report. We are going to take action. Nothing like that, my lord. Just, my lord.
Have you asked for?
No, my lord, I have not, because this has been, my lord, served to me on 20.
Yes,
My-
enough. I've heard Mr. Bhuya. So much of time I wouldn't have taken for main petition.
Fine.
Where is your additional advocate? Okay. Heard Mr. Arrear Bhuya, the learned counsel appearing on behalf of the petitioner. Who appears for that then? Mr. J. Hendrick appears for the respondent number 1. Who appears for the political department? Home and political.
1 and 5, lord.
1 and 5. Who appears for home and political? Anybody appearing?
2, 3, 4, 6, and 7.
Government.
Huh?
2, 3, 4.
Mr. D. Bora appears on behalf of so and so. Okay. Issue notice making it returnable on 26th of July 2023. As the respondents are duly represented, extra copies of the writ petition be served upon the learned counsels appearing on behalf of the respondents during the course of the day.
My lord, by today.
The case of the petitioner herein is agreed by the order dated 21/6/2023, whereby the petitioner has been placed under whereby the petitioner who has been appointed as a registrar
Muslim marriage.
of a Muslim marriage register in terms with the Assam Muslim Marriage and Divorce Registration Act 1935 have been put under suspension on the ground of registration of child marriages by him, thereby violating the provisions of the Prohibition of Child Marriage Act 2006. The case of the petitioner herein is that a perusal of Section 8 of the said Act of 1935, as well as the rules framed therein under, clearly show that, and as well as Rule 26
Rule 20.
of the rules framed therein under, clearly emphasizes that registration of minors, the registration of the marriage of minors in presence of legal guardian is permissible. Taking into account the above, this court prima facie is of the opinion that the petitioner have been made able to make out a case. Accordingly, the order dated 21/6/2023 is stayed till the next date.
Before filing this petition, my lord, did not serve the copy to us, lord.
You get
My lord, we have, right now I have submitted.
Today, my lord, I have received, my lord.
Obliged. My lord.
Supplementary list, item 24 for motion.
Lordship, kindly show our names in the, that,
the registry shall indicate the names of Mr. J. Hendrick, the learned counsel for the
SC revenue.
revenue, and Mr. D. Bora, the learned counsel for the other respondents. Yes, Mr. Gogoi, same matter.
Same matter, the is the LDA assistant. He was by order dated 23, election 9, page 32. He was stopped getting salary.
Idna ta order di summa. Where's my order?
I have.
Information I received, your lordship, in this matter, instruction is, I'm still awaiting your lordship. They are similar matter. The 2015 an inquiry was conducted. And thereafter the report was submitted in 2022.
Mr. Rajkwa, the problem is, if this matter would have come before me for the first time,
Lordship.
I wouldn't have granted a stay. But the problem is the coordinate benches have already granted.
I am.
So I am in a fix on this. So better off. I have already fixed the matter on 25/7.
Yeah.
So this matter also goes with that.
Yes.
Okay.
Lordship.
To Kali ne nom ekita chai loko, huh? It was same order of both.
Yeah. Lordship 25, 26, 27, same.
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 Obliged.
Noted.
Plus.
Twenty-seven,
Same.
28,
In this matters, I am appearing for finance department. Just now, madam.
Huh?
In these matters, madam.
Yes, Mr. Chaudhary, what is your matter?
My lord, the petitioner before lordship, they are all, my lord, the Gaon Panchayat secretaries. By the implement order at page 25, the deputy commissioner has issued orders of transfer. Now, my lord, I am challenging the order of transfer as well as the earlier order at page 24, by which the secretary of the Panchayat and Rural Development Department authorized DC to issue transfer orders.
Hmm.
Now, my lord, these petitioners and my lord, all Gaon Panchayat secretaries, their services have been regularized and they are government employees. That order your lordship will get at my lord page 15. So there is no dispute to that. Now, page 24, your audit comes, my lord. This is a notification by which the Secretary of the Government of Assam and Panchayat and Rural Development Department, may I read the order, my lord?
Yes.
Page 24. For administrative convenience and in the interest of public service, deputy commissioners in general area districts are hereby authorized to make transfer and posting of block development officers, engineers, Gaon Panchayat secretaries, we are concerned with that, my lord, and all other regular officers and staff, including all contractual employees of Panchayat and Rural Development Department within their jurisdiction. Now, my lord, pursuant to this order, and on the strength of my lord, this delegation of authority, the order at page 25 has been passed, by which, my lord, a large number of my lord, the Gaon Panchayat secretaries have been transferred and posted, not in one, my lord, giving two charges of 2 Gram Panchayats. Now, my lord, I am challenging this order primarily on the ground that, my lord, the transferring authority as per the act is the, my lord, director. Appointing authority is also the director. And, my lord, there is no provision of delegation of power to the district deputy commission. If I may draw your lordship's attention to certain provisions of the act, section 30, my lord, of the Panchayat Act says,
Panchayat and Rural Act. In Panchayat Act.
yeah, but the revision for putting
Yes. Okay.
section 30, my lord.
Section 30.
Section 30 says, the staff of the Gaon Panchayat, there shall be a secretary and other staff as may be prescribed by the government in every Gaon Panchayat, who shall be appointed as provided in section 141 and on and or deputed by government from time to time. This sentence is important, my lord. In respect of the provincialized employees, the director of Panchayat and Rural Development shall be the appointing authority. Then your lordship may kindly come to section 62, subsection 4. Section 62, your lordship will find at page 55 in that book. This is regarding staff of Anchalik Panchayat. We are the staff of Anchalik, my lord, Gram Panchayat. But then, my lord, your lordship may come to subsection 4. Subsection 4 says, notwithstanding anything contained in this act or any of the law for the time being in force, the government or the director of Panchayat and Rural Development Assam, as the case may be, shall have the power to effect transfer of the concerned officers and the provincial staff in consultation with the Jilla Parishad contract.
Now, whether similar provision is here also nothing. For Gaon Panchayat, this is for Jilla Parishad, na?
This is for, my lord,
Anchalik
Anchalik
Panchayat.
Panchayat.
And for Gaon Panchayat, the government has the power.
My lord,
That
so,
power is given somewhere.
my lord, I did not find any, my lord.
Now, are these people from Anchalik Panchayat or what?
They
Or
are in
Gaon
Gram Panchayat.
All these are Gaon Panchayat.
Now, if the lordship kindly comes to section 140, section, my lord, 138 at page 116. This is regarding delegations of power to the deputy commissioner. Subsection 2, except where expressly provided to the contrary, the government may delegate all or any of the powers of the deputy commissioner or subdivisional officer under this act or rules framed thereunder this act or to any government officer or gazetted branch. Now, my lord, it is been expressly provided, my lord, that the appointing authority and transferring authority is the, my lord, director. And, my lord, your lordship will kindly note there is no application of mine. Two of the present petitioners, my lord, one is retiring on 31st of July, another is retiring on 31st of August. There is no application of mine also, my lord.
But Mr. Chaudhary, except where expressly provided to the contrary.
Yes, ma'am.
Where is it?
That
There
is,
is
my lord,
nothing on contrary that there cannot be any appointment by or the transferring authority. There can be no other person. can be. There is nothing, there is no mandate to that.
My lord, I have drawn your lordship attention to the fact that my lord, director is the appointing authority, and my lord, the director is the transferring authority. Now it is commissioner, my lord. Of course, it is not implemented here.
No, the word expressly provided to the contrary, meaning thereby it cannot be done.
My lord,
If the word started that other than the director here, nobody can do, then that would the term expressly provided to the contrary will.
my lord, but then my submission to the lordship will be that my lord, the transferring authority has been defined specifically, the director.
But there is nothing stated that other than the director or the government, nobody can transfer.
No, my lord, that is not there, but that
So
is
if
understood.
if that is that, this expression has to mean that only, where expressly provided to the contrary.
Yes, my lord. The contrary provision is that my lord, director will be the my lord, the transferring authority. That is the provision, my lord, specifically stated.
So you mean to say that there can be no other delegation, the appointment has to be made by them only,
Yes, my
transfer has to be made by them only. Now, as regards, just for example, the power which is to be exercised by the, in other aspects by the government, that the government has to pay the particular amount in this manner.
My lord, so
All
there
these
is
are
a provision for that, my lord. There is a provision for that, my lord, in section 123. Your lordship will find it at page 99.
122.
122.
Yes.
Directions from the government. Notwithstanding anything contained in this act, it shall be lawful for the government to issue directions to any panchayat in the matter relating to state and national policies, and such directions shall be binding on the panchayat. The government may call for a record or register or any other document in possession, then require any panchayat to furnish return, plan, etc. Require any panchayat to furnish any information or report or on any matter connected with the panchayat. And these are the provisions. So the power of the government to issue directions has also been, my lord, defined in the act.
No, that I am not saying. Meaning thereby the act categorically mentioned where the government will do.
Yes, my lord.
Then where is the question of delegation?
No, government, my lord, in this section 122 doesn't provide that, my lord, any any order can be passed by the government. The authority is given to the director, now commission.
Where? 122, that is what I am saying.
Right.
Notwithstanding anything contained, it shall be lawful for the government to issue directives.
Yes, my lord, this is directions limited to, my lord, the policy matter.
No, understood.
And
But
such direction,
my specific question is the act categorically mandates which authority shall do what.
Yeah.
If we take what you want to convey, that express unless expressed into the contrary means that where the director or the state government has been directed would be the transferring authority. Then in that regard, nobody else can be. That means this power which is being given under this particular provision of 138 has become useless.
138
138, the power of delegation
is, my lord.
become useless.
No, power of delegation is, my lord,
in
what
which-
is not specifically provided in the act.
No,
The-
it doesn't say.
My lord,
The state government may delegate because they have to have the power to delegate.
yes, my lord.
But where?
This power has been, my lord, defined here in section 138 itself, my lord. In what circumstances you can delegate the power?
No, no, say may delegate any of their power. Any of their power. If 138(1) is seen,
Yes, my lord.
may delegate
Any
any
of
of their
the-
powers under this act or rules framed thereunder except where expressly provided to the contrary.
The contrary, my lord, as I understand it, that, my lord, the director is the, my lord, transferring authority.
No, that will be difficult, Mr. Rod. Because then this has to be something like a non-obstinate clause. Notwithstanding anything, this cannot happen. Which is something like, just for example, if we take the example of section 34(3), you cannot under any circumstances extend beyond this period. So something to that this cannot happen unless therefore were expressly provided to the contrary.
But, that is what I understood from provisions of the law. And in any case, my lord, your lordship will see the application of mine. 2% are retiring, and they do not know, my lord, from where they'll get the salary because my lord, two grand panchayats have been allotted to each one of them.
They will
And my
clarify.
lord, and they are also, my lord, the 2 persons are retiring by 31st of July and 31st of August. And in fact, my lord, what happened? There is some educational program. They have not, my lord, implemented the order yet.
Hmm?
There are some, my lord, education because this has happened only in Tata district. It has not happened elsewhere.
Hmm.
And the order has not been given effect to yet.
We are concerned with which are the petitioners. In fact, these type of petitions shouldn't have been filed together. Anyways, which are the
Petitioners, they are from the same district, my lord.
So maybe. Oh, why not? You make everybody a party. Where are the persons who is retiring?
My lord, petitioner number 2 is retiring on 31st of
2 and 4.
I've stated in paragraph, my lord, 13 at page 11.
Where are you now? In which Gaon Panchayat? 2 is in which Gaon Panchayat?
I have given a table, my lord.
2, yes, Siddheshwar Gaon Panchayat. And 4 is Diwan Gaon Panchayat.
Right. My prayer to my lord, since it has not been given effect to yet, my lord, your lordship will issue notice and consider on the next date, my lord, immediate after vacation. It's a time, my lord, did this state.
No, Mr. Chaudhary, this court is not going to say anything to that effect. As regards 2 and 4, I will ask the deputy commissioner out here to take into consideration that these people are going to retire, to take a consideration not to, if it is possible, not to disturb them. As they are going to retire on July, when did you say?
My lord, the July 31st and August 31st.
As they are retiring on these 2. But as regards the others, this court is not implying.
At least your lordship will notice of the interim prayer.
Okay. Then if I have to issue, why should I then pass any orders for these 2?
I'll leave your lordship.
Heard Mr. M. K. Chaudhary, the learned senior counsel, assisted by Mr. M. Khan, the learned counsel for the petitioner. Miss Petitioner, Miss, your name?
MD Bora for 5, my lord.
MD Bora
Deputy
appears for
Commissioner.
respondent number 5.
The Deputy Commissioner, my lord.
Who appears for the others? You are appearing, NK Devnath. 1 to 4 and 6. Issue notice making it returnable by, when do you want it? We'll have it on 26th of July.
My lord.
26th of July. As the respondents are duly represented, extra copies of the petition be served during the course of the day. The case of the petitioners hearing, the 8 petitioners have jointly filed the incident writ petition challenging the order dated
Both, my lord, at page 24 and 25.
22/5/2023, whereby the office of the deputy commissioner Kachar had transferred 84 persons to various Gaon Panchayats. The petitioners herein are as serial number
My lord, serial number 16, 19,
16, 19,
33, 36,
45,
46, 49, and 80.
and 80.
And 74 and 80.
74 also.
80.
No.
80. No, not 74.
And 80. The learned senior counsel, Mr. M. K. Chaudhary, while drawing the attention of this court, drew the attention of this court to section 30 of the Assam Panchayat Act 1994, for short, the Act of 1994, whereby it has been mentioned that the Director of Panchayat and Rural Development shall be the appointing authority for staff of the Gram Panchayat. The learned counsel, senior counsel, further drew the attention of this court to section 62 of the said Act of 1994, wherein also the Director of Panchayat and Rural Development have been mentioned to be the appointing authority. No. The appointing authority also for the employees working under the Anchalik Panchayat. The learned senior counsel further drew the attention to section 62(4), wherein it has been mentioned that the government or the Director of Panchayat and Rural Development Department, Development Assam, shall have the power to effect transfer of the concerned officers and provincialized staff in consultation with Jila Parishad. It is pertinent to take note of that the said power to be exercised under section 62(4) of the Act of 1994 is in relation to the staff of, is in relation to officers and provincialized staff of Anchalik Panchayat and not Gaon Panchayat. This court further, the learned senior counsel further drew the attention of this court to section 138, wherein the power to delegate have been given to the state government to any government officer of gazetted rank. The learned senior counsel submitted that in view of the language employed in section 138, that except where expressly provided to the contrary, the power of delegation has been given to the government. The deputy commissioner, the power so conferred upon the deputy commissioner by the communication dated, by the order dated, by the notification dated, what is the date? Dated 17/5/2023. Is contrary to section 138 of the Act of 1994. The learned senior counsel therefore submitted that as the Notification on the basis, the notification dated 17/5/2023 is contrary to the provisions of the Act of 1994. The order dated 22/5/2023, by which the petitioners have been transferred, is by an authority who had no jurisdiction to effect such transfer. The learned counsel, senior counsel, alternatively further submitted that the petitioner number 2 and the petitioner number 4 are on the verge of retirement, in as much as the petitioner number 2 is retiring on
31st of July.
31st of July, whereas the petitioner number 4 is retiring on 31st of August. And the respondent authorities, more particularly the respondent number 6, 5, did not take into consideration that the same and transferred the said petitioner number 2 and 4. I've also heard Mr. M.D. Bora, the learned counsel, appearing on behalf of the petition respondent number 5. Who submitted that section 30 of the Act of 1994 only refers that the director of Panchayat and rural development shall be the appointing authority. He further submits that section 62 is in relation to the staff of Anchalik Panchayat and not for the staff of Gaon Panchayat who have been transferred in the by way of the impugned order. The learned counsels therefore submitted that the bars so imposed under section 62(4) would have no consequence in the exercise of the powers under section 138 of the Act of 1994. And to that effect, the learned counsel therefore submitted that the notification, a perusal of the notification dated 17/5/2023 restricts therefore to the Gaon Panchayat secretaries upon hearing the learned counsels. I am of the opinion that the said contention so raised prima facie in the opinion of I'm of the opinion that the contention so raised that the notification dated 17/5/2023 is contrary to section 138 of the Act of 1994. I am of the prima facie opinion that on the face of it, the notification dated 17/5/2023 does not show that the said aid contrary to section 138 of the Act of 1994. And under such circumstances, this court is not inclined to grant any interim order at this stage. This court further takes note of that the petitioner number 2 and petitioner number 4 are on the verge of retirement. Under such circumstances, this court therefore requests that the respondent number 5 to take appropriate steps so that the petitioners number 2 and 4 can be continued in the same place of posting till they retire. List recording.
I'm deeply ashamed.
Ask your deputy commissioner to do the needful, not
My
to
lord.
transfer these.
Right now, I'll communicate.
Yes. Oh, 115.
Production list item number 1.
The appeal stands dismissed. Before parting with the record, this court finds it relevant to note that at the time of admission of the instant appeal, this court had stayed the impugned judgment and award dated so and so, subject to the deposit of 50% of the awarded amount by the appellant insurance company. Pursuant to the said order, an amount of 33,82,724 was deposited on 11/3/2022, and the said have been released to the respondent claimants in equal proportion to each of the claimants, as could be seen from the order dated 24/5/2022 passed by the Registrar General of this court. This court further, during the course of the hearing, had also heard on the issue pertaining to the remaining amount to be paid and as to how the interest of the claimants would be protected, more particularly the minor children. This court further asked both the counsels appearing for the appellant as well as the respondent claimant to submit a detailed calculation as to how much amount would now be further payable to the claimant if the appeal is dismissed, and the counsel for the appellant and the respondent have jointly placed the calculation sheet signed by the counsels. The said calculation sheet is kept on record and marked with the letter X. From the said calculation sheet, it appears that the claimant would be further entitled to an amount of rupees 65,66,172. This court, therefore, taking into account that the claimants have already received an amount of rupees 33,82,724, and the future requires to be protected, more particularly to the minor children, therefore directs the appellant insurance company to deposit the amount of rupees 65,66,172 to the learned tribunal before the learned tribunal within 6 weeks from today. Upon deposit of the said amount, the learned tribunal, that is the court of the MSCT Borpeta, shall invest us in the name of the claimant number 3 and 4 an amount of rupees 14,83,068 each in fixed deposit in the favor of the respondent number, in favor of the claimant number 1 and 2. Further, an amount of rupees, further to that, an amount of rupees 18 lakhs each shall be invested in favor of the minor daughter of the claimant number 3, that is the claimant number 3, and the minor son, that is claimant number 4, in fixed deposit. The said fixed deposit shall be made in a nationalized bank for an initial period of 5 years, The interest so accrued on the said fixed deposits shall be paid to the claimants in their respective savings bank account maintained in the bank. It is also provided that in case of extreme necessity, the claimant shall be entitled to encash the fixed deposit on obtaining the necessary permission from a learned tribunal. Yes, Mr. Mazumdar.
I have my instructions, my lord. She's ready to forgo the. It will not be a.
Yes, now tell me.
Lordship, in anywhere, Lordship, her normal tenure will also be completed by 21/7, the 4 years. If she forgive her promotion also, Lordship.
Hmm?
If she forgive her promotion also, then also by 21/7, her normal tenure will be completed. And although, Lordship, there is no financial benefit, Lordship, because it's as per MSCP and the present financial benefit which she is getting, that is from 2014 she is getting. So next she will be getting it from 2024. But there is differences of duties regarding constable and head constable, etc., Lordship.
Working in the family welfare center, my lord, I'm told.
And her rank has to be reduced, Lordship, in that case.
Hmm?
Rank has to be reduced, Lordship. Reduction of her rank is also there, Lordship, if she forgive her promotion.
Okay, have you submitted a representation?
My lord, I had submitted I had submitted my application for childcare leave.
Where?
Lordship will find the page 27. Page 28, I'm sorry, Lord, page 28, and in the format at page 31. Page 20 to 31. I submitted on 8/6/2023.
Now, where is the decision?
My lord, that nothing has been done on this. In fact, at that page, the former page, my lord, at page 27 or 27A, my lord.
When
Serial
did you
number one,
submit this? When did you submit this? 8/6.
8/6 was submitted on 8/6.
Then
Then nothing happened. Nothing has happened till now. They proposed to relieve me, therefore I propose this court, praying that they let them consider the child care leave application. Done with the leave, I'll go and join. They relieve me on my, after giving me the leave, I'll go and join. On my finishing my leave, I'll go and join at 2:30 to Bettigan.
show me your right for childcare leave.
Child care leave, my lord, that lordship will find at the page 43. This is part of the CCS leave rules. Page 43, I have put it in. Para 14. A woman government servant having minor children below the age of 18 years and who has no earned leave after credit may be granted childcare leave by an authority competent to grant leave for a maximum period of 2 years, that is 730 days during the entire service, for taking up care of her 2 children, whether for rearing or to look after any of their needs like examination, sickness, etc. During the period of childcare leave, she shall be paid leave salary equal to the pay drawn immediately before proceeding on leave. Childcare leave may be combined with any other kind of leave, notwithstanding the requirement of production of medical certificate contained in sub-rule 1 of Rule 30 or sub-rule 1 of Rule 31. Leave of the kind due and admissible, including commuted leaves not exceeding 60 years and leave not due after maximum 1 year, if applied for, may be granted in continuation with childcare leave. So if lordship permits 2 judgments.
Now, what is Annexure 11?
Annexure
Page 46.
Page 46, that is the transfer policy maintained by the CRPF, my lord.
Lordship, this is exceeded by another standing order, Lordship, 4 of 2022. This is not in existence now, Lordship.
What is
Annexure 11.
What is the difference?
At page 59 is the transfer of Mahila personnel in that case, my lord.
Eight.
Page 59 is the transfer of the lady constable. In this is the last one I have.
This policy doesn't exist.
That is
what she.
There is a difference in that, my lord, but in my case, I'm not challenging the transfer as such. I'm not challenging the transfer. I am ready to go there but my child care leave, if lordship will allow me, Place two judgments of the
But
Honorable
how
Court.
can this court allow you? Isn't it said may grant?
My lord, this Honorable Court in other cases have held that the welfare of the child so far as the mother is concerned, child care leave, my lord, almost becomes it is a beneficiary provision and has to be given the liberalest of the, they have to take the most liberal approach while granting me the leave. One should not be denied that leave. In my particular case, if lordship will find they do not want to retain me here only on the ground that I require a mandatory field service for my next promotion. It is not because they are running short of people there.
Where is it?
Yes, my lord. Lordship will find at page 27, the rejection of my retention.
Rejection of what?
Of the extent, I had paid for a further extension of 1 year, where when refused, I paid for childcare leave. Page 27, approved list AGD, release of promotion from constable so-and-so, representation for change of posting regarding, please refer to IGNS letter number so-and-so. Lordship will come to the table. Serial number 1, this is the petitioner, reasons. She has to complete 2 years mandatory field service in the rank of head constable GD for the next rank promotion. But I was promoted only on the last year. My next promotion to the post of assistant sub-inspector is coming some 10 years later. They want me to complete my mandatory field service now. That is the only reason given. The original is at page 27 on the next page.
But they have not decided on the question of your childcare.
That is the whole thing. I applied on age 6. I wanted leave from 26. When they did not grant me the leave till 26 and proposed my relief, I am before this honorable court praying that my childcare leave may be taken into consideration and I may be relieved. I will go and join after my leave.
Prior to that,
That is
lordship,
the long short of it, my lord.
page 22, her previous application, lordship, where there is no mention of child care leave.
That is because I wanted
By
an
that,
extra
she had
2 years
asked
of
for
leave.
another 1 year deferment of her transfer. Already
reason
she
remains
had
the same.
received 6 months, more than 6 months deferment we have already
Not on
provided
this.
to her. Then lordship, this annexure 5, page 22, she had again applied for another 1 year. And here, after that, the third one, the child care leave and earned leave.
Lordship,
Why
at
you
page
have not
22 she is
decided?
referring-
Lordship, our case is that lordship, she is entitled to child care leave. Lordship, let her join there, and as per the procedure and as per availability, the commandant of the new place of posting where she was posted to Mahila Battalion, they will provide lordship. It's not that she is denied from leave, lordship. And what is
No,
the
only thing is, madam, I'm only asking whether now after the promotional order,
lordship?
you retain the jurisdiction to grant leave or not.
Difficulty if we grant her leave from here, lordship. In that case, lordship, she will be attached with our battalion, lordship. In that case, we cannot post another person in her place. She will be in leave and she is officially with this battalion. That is the difficulty, lordship. We cannot appoint anybody in her place, but she will be in
No,
leave,
no,
lordship.
that is an administrative difficulty which this court will duly take care of.
Lordship.
I'm not on that. But do you still have the power to grant the leave? I'm on that specific.
Specific, lordship.
That they have done for 2 other litigants in earlier rounds. They have
No,
granted-
I am not on negative equality.
No, I'm not on that, my lord.
I'm not on.
They have the power.
I'm
That is
only
not just
asking
I'm
you
saying that they have the
whether
power to
you
grant
have,
leave.
you still have the authority on.
In date of relief, my lord, I'm a person here.
Paragraph I, lordship.
Where
I.
May issue order to grant CCL or ER or both to the petitioner, then in such secondary it may also be paid before it's found that after availing the petitioner has to report to IMAN and she may extract from the strength of GCC Guwahati so that some of the Mahila person who has completed the 10 years in the No, this you are putting the ball on before this court. I'm not on that. I am asking you, do you still have the authority?
From this, one thing is clear that
You
lordship,
won't grant it is a different thing. I'm not on that, man. I'm only asking whether you still have the authority to grant the leave. That is my specific.
Yeah.
Have the authority, that is a different. If you don't have the authority, because after a promotion, a person is now being posted out there. then in that case, would that authority be the only authority who will have?
After she joined their lordship,
No, not join.
not joined.
As of now. Till she joins. I think it is you who shall have the authority. Heard Mr. R. Mojumdar, the learned counsel, appearing on behalf of the petitioner. Miss
B. Sharma.
B. Sharma appears on behalf of all the respondents. The instant writ petition is taken up for disposal at the motion stage itself. The case of the petitioner herein is that the petitioner was promoted by an order dated 7/9/2022 to the post of
Head Constable
Head
General Duty.
Head Constable General Duty and was posted at 232 Battalion BN. Thereupon, the petitioner had submitted a representation stating that her husband have earlier never posted
He and her husband were never posted together in a static location.
were never posted in static offices and were posted in operations and Naxal affected battalions since enlisted in the force. It was further mentioned in the said representation that the petitioner has two children who are studying at Guwahati. The elder child is studying at class 7, and the younger is in the second standard. It was further mentioned that the individual, further mentioned by the petitioner that on promotion in the middle of the year, the education of our children will be interrupted. And therefore requested that the petitioner be retained in her GCE's
Group Center.
group center till SCT,
Summer Chain Transfer. Summer Chain Transfer.
Summer Change Transfer Dash 2023 for better education of our children. It further reveals that on 17th of March 2023, the petitioner was retained in her group center till SCT-2023 by the DIG establishment. On the basis of a signal dated 11/11/2022. It was further mentioned that the petitioner may be relieved after 31/3/2023 and to intimate her the date of relieving for further needful action. Thereupon, the petitioner submitted yet another representation for deferment of 1-year tenure in group center.
Therapy.
to her representation by an order dated 26/5/2023. The representation of the petitioner was rejected by the competent authority on the ground that she has to complete 2 years of MFS. What is that?
Mandatory field service.
Mandatory field service in the rank of head constable, GDs,
General duty.
general duty for next rank promotion. Thereupon, on 8/6/2023, the petitioner submitted an application seeking childcare leave to look after her children. In the said application, she had mentioned that she had in total 510 days
Required.
she had accumulated 579 days of childcare leave, of which she wanted to avail 450 days and 60 days of earned leave for the year 2023, with effect from 26/2023. The said application is yet to be disposed of. Said application is yet to be taken into consideration by the competent authority of the respondents. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the notification dated 1st of December 2009, wherein
The amendment to
the Central Civil Service (leave) rules 1972 was amended, thereby inserting Rule 43C. Taking into account the relevance of the said rule, the same is reproduced hereunder, page 43. A perusal of the above rule reveals that a woman government servant having minor children below the age of 18 and who have no earned leave at her credit, may be granted childcare leave by an authority competent to grant leave for a maximum period of 2 years, that is 730 days during the entire service, for taking care up to 2 children, whether for rearing or to look after any of their needs like examination, sickness, etc. Therefore, subrule 1 of Rule 43C grants the competent authority a discretion to grant childcare leave for the reasons mentioned therein. Now, coming back to the facts involved herein, the petitioner claims that she has 579 days of childcare leave. And the petitioner seeks to avail 450 days thereof. No, 50 days. Out of the said 579 days. The question to grant or not, no, no. It is well settled that to claim leave, no, well settled that leave is not a matter of right. And would be subject to the discretion to be exercised by the authority competent to do so. In the instant case, the petitioner herein has a child who is presently pursuing her, one child who is presently pursuing her studies in the 8th standard. And the other child is in the 3rd standard. The husband of the petitioner is presently posted at
LW area, my lord, 135 battalion.
At 135 battalion, which is
133 battalion, my lord,
which is
left wing extremist area.
left-wing extremist area. These aspects of the matter are therefore required to be taken note of while exercising the discretion by the authority concerned. This court has also taken note of that on 8/6/2023, the petitioner had submitted the leave application, which is yet to be considered by the competent authority. This court, therefore, is of the view that is of the opinion that the interest of the justice would be met. That an opportunity be granted to the authority concerned to take a call on the application so filed on 8/6/2023. By exercising the discretion, taking into account the relevant factors which have been mentioned here in above. Accordingly, this court therefore disposes of the writ petition, directing the concerned respondent authorities move on.
Number 3, my lord.
Did you know?
Application was made to respond number 3. I'm not 3, 4.
I think
5. 6. 6. Respond number 6.
Respondent number 6 to decide the application dated 8/6/2023 filed by the petitioner. Within a period of 15 days from the date of the instant order. Date of instant order. Till such time the said application is decided, the petitioner may not be. What do you want?
May not be relieved, my lord.
May not be relieved from the group center. What is that?
Group center,
HD.
Group center, CRPF, Guwahati.
With the above the petitions. That's
Okay.
you also got here.
I know
Hey,
29.
Madam, you take that. Yes, madam.
Your Lordship. Lordship, matter relates to finalization of family pension. Lordship, the petitioners herein are The husband and daughters of a government servant, Lordship. Rumi Bora. She died on 25/6/2017, Lordship.
Mm.
Thereafter, they applied for the pension.
Mm.
Annexer 8, Lordship, from Inspector of Schools forwarded the pension proposal to the Director of Pension, Lordship.
Now, there's an order of provisional pension also.
Provisional
You are
pension
getting.
is there, Lordship.
You died in service.
Lordship.
It can't be. There was a VRS.
She applied for VRS, Lordship.
Did she get the VRS? You see, kindly come to page 23. 23 or 27. 28. Annexure 10.
Yes, madam. 26,
28.
28.
Pay Annexure 10.
Yes, madam. Here, madam, the objection is that as the expired government servant was in extraordinary leave on medical ground with effect from 1/6/2010 to 31/8/2013, during that period, granting of increments and ACPS were irregular. Do the needful. Submit a copy of VRS order and a noting of VRS order in immediately for settlement of the pension case. Yes, in fact, from the petition pleadings, my lord, he has applied for the VRS, my lord, but whether it was granted or not, that is not discernible from the petition, my lord.
What have you done? It was given to the inspector of school.
Yes, my lord, on 8/7/2020.
What have you done?
That instruction I have to obtain, my lord.
Only another 7 days left to complete 1 year.
Yes, ma'am.
Third, Miss
P. Sharma, Lord.
P. Sharma, the learned counsel for the petitioner.
I'm appearing for 1, 2,
Petitioners, huh?
and 4, my lord.
Mr. N.J. Khatoni appears on behalf of the respondent number 1, 2,
and 4.
and 4. Miss, why you made the headmaster a party unnecessarily? Anyway, Mr. S.R. Borwa appears for respondent number 3, and Mr. A. Sulia appears for respondent number 5. Issue notice making it returnable. How much time?
But,
Yeah, after vacation.
after application, my lord, 3.
Issue notice making it returnable on 2nd of August 2023. As the respondents are respondent number 1 to 5 are duly represented, extra copies of the writ petition be served during the course of the day. As regards the respondent number 6, steps be taken by way of registered as well as usual during the course of the day. The case of the petitioner herein is that petitioners are entitled to family pension upon the death of the petitioners are entitled to the family pension on account of their mother, the petitioner number 1's wife is entitled to the family pension. However, though provisional pension have already and provisional DCRG have already been sanctioned and disbursed to the petitioner, but the final pension have not been paid to the petitioner. In view of a communication dated 8/7/2022, whereby the Finance and Accounts Officer of the Director of Pension had written a communication to the Inspector of Schools, Nagaon, to comply with certain requirements and to remove certain deficiency and to resubmit the pension proposal. It is the case of the petitioners that pursuant to the communication dated 8/7/2022, nothing has been done from the end of the Inspector of Schools Nagaon, and for which the respondent authorities have not granted the final pension and the final provisional pension, final DCRG entitlement to the petitioner. The respondent in the education department as well as the director of pension is therefore directed to apprise this court on the next returnable date as to what steps have been taken by the Inspector of Schools Nagaon pursuant to the communication dated 8/7/2022. The counsel appearing on behalf of the Director of Pension shall also apprise as to that in the circumstance the education department have taken steps, what steps the Director of Pension have taken in respect to the family pension of the petition. List according.
Obliged.
At number 16.
Yes.
Here the director of the
Third benefit in terms with notification have not been granted. Why?
Lordship, that Director of Elementary Education by communication dated 28th June, Lordship, has sought for some report and as well as relevant documents from the DEO, Lordship. So once that report comes, Lordship, that will.
M. Hussain.
Yeah.
Heard Mr. M. Hussain, the learned counsel for the petitioner, and Mr. P. N. Sharma appears on behalf of the respondent number 1, 2, 6, and 7.
Lordship.
The learned counsel therefore submits that pursuant to the order passed by this court on 19/5/2023, the Director of
Elementary Education, Lordship.
Elementary Education have written a communication to the
District Elementary Education Officer, Barpeta.
DEO Borpeta, seeking certain instructions in the matter. The said communication was issued on
28th of June, 28/2/8,
yes.
day before yesterday.
Why?
But that is not the announcement.
Why?
28th of June, 2020.
Was 28th of June 2023. And as such, some further time is required in that matter. It is relevant to take note of that this court had specifically directed the elementary education department to apprise this court why the third benefit in terms with the notification dated 6/7/2017 have not been granted to the petitioner, thereby making it returnable on 30/6/2023. It surprises this court that the Director of Elementary Education wakes up to issue the communication on 2 days before. That is on 28/6/2023. Taking into account the above, this court fixes the matter again on 9th of August 2023. It is directed that both the Director of Education, Elementary Education, as well as the District Elementary Education Officer, Borpeta, are directed to take appropriate steps so that in the meantime, so that the proper and relevant instruction is placed before this court as regards the query made on 19/5/2023. List record.
17.
Next to good.
Outline. Lordship, here also similar player lordship. The director again on 28 communicated to the DO on receipt of the letter from the Secretary of School Education Department.
Heard Ms. D. Borgohai, the learned counsel for the petitioner. Mr. P. N. Sharma appears on behalf of the respondent number 1, 2, and 4. This court, by an order dated 22/5/2023, have duly recorded that the petitioner claims to be entitled to an amount of rupees 11,79,692 on account of the increments to which the petitioner is entitled for the period from 1/4/1999 to 30/6/2019. This court had also duly taken note of that the government, that the Department of School Education had granted similar reliefs to other persons, as could be seen from Annexure 9. This court further directed by the order dated 22/5/2023 as to why the petitioner have not been granted the benefit as claimed in the writ petition. It, however, surprises this court to note that the Director of Elementary Education have only taken steps in pursuance to the order dated 22/5/2023 on 28/6/2023. This court again fixes this matter on 11th of August 2023. This court further puts the Director of Elementary Education to notice as to why interest should not be imposed upon the Elementary Education Department for delay in payment of the area salary to the petitioner. An affidavit be filed by the Director of Elementary Education by 7th of August 2023. No, by 9th of August 2023 without fail.
19.
এই আগৰ অৰ্ডাৰটোৰ এইটো অৰ্ডাৰ দুইটাতে এটা লাইন লিখিব। Mr. P. N. Sharma, the learned counsel appearing on behalf of the Education Department, shall apprise the concerned Director of Elementary Education as well as the Director of the District Elementary Education Officer itut agortut about the order so passed hearing or itut so and so to the Director of Elementary. Then we can catch hold of you. Yes, Upendas. Oh, other side is not there. Hello, leave the matter after vacations.
20.
It is not.
Yes,
Roger, page 15, NHSC.
your forest.
Yes, Your Lordship.
Yes,
Today is the last day of the
who is
36th.
presently serving as the divisional forest officer is aggrieved as a part of the notification dated by the officer that he was transferred to be transferred and posted in the post presently held by the petitioner. However, there is no alternative posting is given to the petitioner in essence, he is going to retire very shortly. Retire today,
He's set to retire in the course of the day, your lordship, in the next couple of hours.
then? So nothing survives.
Nothing will survive after he retires.
Till then the impunity state.
The lordship will fix the matter another day and close the matter thereafter, or your matter, lordship will close the matter today itself.
Huh?
The lordship may close the matter now. Or
He is retired.
yes, in the process of retiring, that's just a formality.
That was state.
That was
Lordship may close the matter.
Nothing survives.
Yes.
You are not going to disturb him today.
Oh, your lordship.
Heard Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner. Yeah, M.K. Chaudhary. M. Sharma, the learned counsel appearing on behalf of the petitioner. Madam, your name?
Miss Sabina Ahmed.
So and so, the learned counsel appearing on behalf of the Forest Department.
Yes.
First, the learned counsel appearing on behalf of the Forest Department had submitted that in view of the order dated 16/6/2023, the Forest Department, respondent Forest Department would not be pressing on the order dated 16/6/2023 insofar as the services of the petitioner is concerned. As the petitioner is going to retire today. Under such circumstances, the learned counsel for the petitioner submits that in view of the specific undertaking given by the counsel for the Forest Department, he would not like to press the petition. Accordingly, the petition stands closed in view of the undertaking given by the Forest Department counsel.
22.
Yes.
My lord, the order dated 7/6/2020.
What is that?
My lord, instruction from respondent 1, 2, and
She
3.
sought in under the remand the reason for non-disbursal. The respondent intimated her that the pension of the period was returned by the central paying account which on remand. The pension will be processed only after receiving clear instruction from the pension and welfare. Pension and pensioners welfare. What is that department?
This is under the Ministry of Personal Law.
Interesting. Now, what is the instruction?
Lordship, so far, no instructions, but the instructions, relevant instructions has to come from the Ministry of Personnel, Department of Pension, because some policy decision has been taken pursuant to which this status has come. Lordship, if he has not made them a party, Lordship, if there is an observation from your Lordship, otherwise I'll have to circumvent and go.
Whom should be made
This,
party?
Ministry of Secretary, Ministry of Personnel, Department of Pension and Pensioners Welfare.
They have not been made a party.
No, they have not been made a party because, my lord,
Did he say? He says that the respondent number 5 who is
Respondent
that?
number
that
5,
is-
in my understanding, my lord,
that
was the
is-
one to have
That is
coordinated.
Airport Authority, Lordship.
Huh?
airport, your lordship.
That is Airport Authority.
Wait. Respondent number
Respondent
5
number-
is some deputy general manager.
Yes, CAD pension cell of the concerned airport. But what my senior friend, my lord, is trying to suggest, my lord, is
Mr.
that-
D. Chakraborty, the learned counsel for the petitioner, Mr. R.K. Dev Chaudhary, the learned DSY. What is the DSY?
DSGI.
DSY. Deputy Solicitor General of India. Who appears for the respondent number
1, 2, and 3.
1, 2, and 3.
For respondent numbers 4, 5, 8, and 9, your lordship.
Mr. N. Chaudhary appears for respondent number 4, 5,
8 and 9.
8, and 9. When so appears for the who? What about 10?
10, I think, my lord, service will have to be awaited. It was
Okay.
issued.
10. It reveals from the office note The office notice is not clear as regards the service upon the respondent number 10. The learned counsel for the petitioner submits that he may be permitted to take fresh steps upon the respondent number 10. Mr. R.T. Dev Chaudhary, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 submits that the Department of Pension and Pensioners Welfare is not a party to the instant proceedings. He submits that without the said department, a proper adjudication of the instant dispute cannot be made. Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, orally submits that the said department, that is the Ministry of
Ministry of Personnel Law.
Personnel,
Secretary,
Department of
Ministry of Personnel,
Department
Department of Pension and Pensioners Welfare,
Pensioners Welfare, having its office at
Delhi Law.
New Delhi.
New Delhi is so small.
Lok Nayak Bhavan,
Ah.
Khan Market, New Delhi, 110003.
Be added as a Impleaded as the respondent number 11 to the instant petition. So, taking into account the submission made by the learned counsel for the petitioner, as well as that for effectual adjudication of the instant petition, the presence of the Ministry of Personnel, Department of Pension and Pensioners Welfare would be required. This court impledes the Ministry of Pension, so and so the address to delay as the respondent number 11 to the instant petition. Mr. R.T. Dev Chaudhary, the learned counsel also accepts notice on behalf of the said newly impleaded respondent number 11. Extra copies of the petition therefore be served upon him during the course of the day. The petitioner further is directed to file an amended memo of parties before the registry of this court. And upon such filing, the registry shall make changes to the insert the name of the respondent number 11 in the records of the instant petition as well as in the CIS. List again on how much?
2 weeks.
2 months?
2 weeks.
Too early? List the matter again on after independence, 16th of August.
Perhaps.
Actually, may kindly direct that name of Mr. P.T. Dekha might be
Where is he?
in the cause list.
Where is he?
He is on like
44 and file your whatever you want to file. Then you will. Yes, Mr. Gupta.
My lord, as instructed by the petitioner, my lord, they have been called to the SP office for submitting some documents.
Hmm.
And my lord, my additional affidavit is not on record, my lord. My additional affidavit, you filed it. But
What is this? Oh, no, what
there
is the
was some-
matter about?
My lord, there was
Voluntary retirement. Oh, yes. What happened?
Your Lordship, I have faith.
Oh, 26. Mr. Aswal appearing on submitted that it has already been filed. Mr. Eber submits that requires 1 day time to obtain the incomes with the order dated so and so.
Your Lordship, this is not the. This is
Wait. With reference to that, I'd like to say that in the end of proportional pension to the husband of the man that submitted Yes, everything is going to be done.
But, let the matter be listed after vacation. In the
What?
meantime, they will get the pension, my lord. Let the matter be kept pending. Because I have also claimed, my lord, interest, my lord, because
When did you inform your husband expired? Tell me.
that information I have taken, my lord.
You did not inform. They called you up in view of this order.
That
And
I
now
have
you are
to-
asking for interest.
That I have to check, my lord.
What do you have to check? We do one thing.
Well.
We allow the petition, impose a cost upon Mr. H. Gupta of 10,000 for not explaining it to the club. Okay. Heard Mr. H. Gupta, the learned counsel, appearing on behalf of the petitioner. Mr. D. Bora appears on behalf of the
Response numbers 1, 3, 5, 6, 7, and 8.
Lordship, status appear for respondent number 4.
anybody else?
That's why I'm updating for 2 in. Respondent number 2.
And so appears for- The case of the petitioner herein is that the petitioner is the wife of one Moneswar Basumutari, since deceased. During the lifetime of the petitioner's husband, a PPO number 9042411285439 was issued. However, the husband of the petitioner did not receive a single penny on account of pension and expired on 14/9/2020. The petitioner thereupon have been running from pillar to post and pillar to post for the area pension to which the husband of the petitioner was entitled to, and also for the family pension to which the petitioner is entitled to. However, the respondent authorities have not ventilated the grievances of the petitioner, for which the petitioner had approached this court by filing the instant writ petition. This court, by an order dated 1/3/2023, passed the detailed order, thereby directing the councils appearing on behalf of the Department of Home as well as the Director of Pension as to why the petitioner have not been, why the husband of the petitioner did not receive the area pension, why the petitioner would not be entitled to the area pension to which her husband was entitled to, as well as also to the family pension. No meaningful instructions was obtained on the earlier dates. Today, however, the Learned Counsel appearing on behalf of the Home Department have placed an instruction issued by the Superintendent of Police B, Assam, dated 28/6/2023. In the said instructions, it has been mentioned that as regards the granting of the proportionate pension to the husband of the petitioner, as per government OM number PPG bracket P 12/2019/1 dated 21/1/2019, the Office of the Special Director General of Police Border Assam had submitted the pension case in prescribed format in respect of the husband of the petitioner by the letter dated 21/6/2021 to the Additional Director General of Police bracket MNL Assam Guwahati. Subsequent thereto, the Accountant General A&E Assam had sanctioned his pension and issued PPO bearing number 902411285439 by audit effacement. What is this? Effacement?
I'm also not aware.
Okay. Well, he will know. He knows. What is this? Your central government council has all this. Nobody else. By an audit effacement dated 8/4/2022 in respect of the husband of the petitioner. It has been further mentioned that the service gratuity have already been given to the husband of the petitioner by DOO number 56 dated 12/1/2017. However, leave encashment would be paid to the petitioner shortly. It was also stated that it was only in view of the filing of the instant writ petition and the order being passed by this court that the office had come to know about the demise of the petitioner's husband. Subsequent thereto, the petitioner was communicated with a request to approach the Assam Police Border Headquarters by memo dated 17/3/2023, and the petitioner along with her elder son appeared before the Superintendent of Police Border Assam on 18/3/2023, and the formalities for pension have been initiated. Further to that, it has been mentioned that the family pension along with arrears will be given to the petitioner on getting necessary approval from the competent authority. The said instructions so placed is kept on record and marked with the letter X. Taking into account the above stand, this court is of the opinion that the interest of justice would be met if the instant writ petition is disposed of, passing consequential directions upon the concerned respondent authorities to complete the entire exercise so that the petitioner receives the leave encashment as well as the arrear pension and the arrear family pension within a time frame. Accordingly, this court therefore directs the Home Department of the government. Which department should I direct first?
It's an additional Director General of Police Border Assam.
Who is he?
In this
Directs the respondent number 6 to take appropriate steps so that the petitioner receives the leave encashment, the arrear pension to which her husband would have been otherwise entitled to, if not already paid, the area family pension to which the petitioner would be entitled to, as well as the family pension to which the petitioner would be entitled to henceforth within a period of
3 months, my lord.
3 months from the date of the instant order. From the date, not 3 months from the date a certified copy of the instant order is served upon the respondent number 6. It is further directed that the Accountant General, Office of the Accountant General, Assam, shall the Director of Pension has any role?
No.
Shall do the also the needful so that the petitioner receives the payments as directed within the time frame. A copy of the certified copy of the instant order shall also be submitted to the respondent number 4.
Highly opaque. Great.
45.
Yes, Mr. Sharma.
Lordship, I have received the instruction.
Heard Mr. M. Khan, the learned counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the Elementary Education Department, and Mr. S. R. Buru, the learned counsel, appears for the Director of Pension. Now, Mr. Buru, tell me one thing. With this, after this, what are you going to do?
Lordship will finalize the pension.
So I'll direct them to finalize the pension.
Lordship.
Should I direct the finalization of the
Can we
pension?
dispose of-
Huh?
Lordship.
Interest in this case was it. That's what it may be drafted. It was 197A. Lordship. There was a delay on the part of the respondent. This is the second round of litigation. Petitioner is waiting for 2010.
Okay, who should pay? When does your entitlement to get the pension arises?
My entitlement lordship from 1/6/2010.
How?
I retired from service on 31/1/2000.
You didn't have the pensionable service. There was a requirement of condonation. When did the condonation happen?
That direction was given by this honorable court lordship.
There was no direction given. There was a consideration given.
Yes,
Then
that was in 2/12/2016.
understood. But then
Have not applied. Now, after this proceeding lordship, they have
now they have only granted the condonation. Not then, isn't it? So whom should we impose the interest?
by the authority.
Whether the elementary education or the director of pension would have granted without the condonation.
Donation matter, whatever decision they have to take, that should be taken within a reasonable time. Because this order was passed on 2/12/2016.
Then have you challenged the condonation application? You want to challenge it? You want to challenge it, then I will keep it. I'll give you the leave for challenging the condonation. You challenge the condonation, so it has been delayed. Because unless you challenge the condonation, that it has been done delayed, very belatedly. Because otherwise, the 197 will be when a person is entitled to pension and being not granted. Your entitlement only comes after the condonation.
Yes,
And the condonation happened only the recent. Don't you think so?
but that is after a long time.
Understood. For that, you go and file a civil suit. What do you want? You will challenge the condonation. I give you the leave. Then we can pass an order. You want to challenge the condonation? Challenge the condonation.
Director.
Huh?
No, it not. We are possibly director. It is the
In pursuance to the orders passed by this court on 3/5/2023, 12/5/2023, and 24/5/2023, it reveals that the government had accorded the approval for condonation of the shortfall of qualification of service for pension by invoking the power under Rule 67. On
29/5, Lord. 29/5/2023.
29/5/2023. Thereupon, it reveals that the Director of Elementary Education had taken certain steps so that the petitioner receives his pension. It is further relevant to mention that the Director of elementary education. Had issued a communication on 26/2023, thereby directing the district elementary education officer to take necessary steps for finalization of the pension in the light of the government's letter dated 29/5/2023. Today, Mr. P.N. Sharma, the Learned Counsel, have placed a communication dated 28/6/2023 issued to the Director of Pension, wherein it has been mentioned that the reconstructed service book in respect of the petitioner have been finalized. Reconstructed service book in respect to the petitioner whose pension have been finalized from the Office of the Director of Pension Assam by PPO number ADP/ZPO/2012/043. After condoning the shortfall of qualifying service by the government by communication dated 29/5/2023 for pension, have been submitted to the Director of Pension. The Director of Pension, therefore, was requested to take necessary steps towards the finalization of the pensionary benefits of the petitioner. This court also heard Mr. S.R. Borua, the Learned Counsel, appearing on behalf of the Director of Pension, who submitted that upon receipt of the documents, the Director of Pension shall do the needful within a time frame. No. The Learned Now, Mr. S.R. Borua received. Mr. P.N. Sharma further submits in this regard that the Director of Pension have also received the documents on today itself, as could be seen from the endorsement made to the communication dated 28/6/2023. Taking into account the above, this court therefore disposes of the instant writ petition with a direction to the Director of Pension to do the needful so that the petitioner receives his area pension as well as the pension and other pensionary benefits to which he is entitled to in accordance with law within a period of
1 month.
1 month. From the date a certified copy of the instant order is submitted to the Director of Pension. The copy of the communication dated 28/6/2023 is made a part of the record and marked with the letter XYZ. A. Last.
47.
Yes.
That is a lot. Also, in this case, in the name of initiation of disciplinary proceedings, the respondent authority just appointed the inquiry officer and presenting officer. That is annexure 2. Nothing beyond that. And it is more than 1 year. More than 1 year. Lordship has already reflected in order dated 23/23, my lord. Lordship's order, my lord. Lordship, as per last election, and also in for term
Yes, tell me. Now, what has happened to the disciplinary?
It is going on, Your Lordship. Right now, the presiding officer has been appointed.
That has been appointed 1 year ago.
1 year back, and because of this pending department, this criminal proceeding, they could not proceed further.
So should we record that?
No, Your Lordship, because it is
Ah.
not in written, Your Lordship. But
Then-
on last occasion,
Then we stay, that the departmental proceedings has to be stayed then.
Your
We are
Lordship,
saying that.
no, Your Lordship, I'm not saying that. Your Lordship, both of them can go for parallelly. But the thing is, on last occasion, Lordship instructed me to get the instruction with regards to the provisional pension, because that's what he has been actually claiming in the writ petition.
Hmm.
If we
Now
go
you
by
are
the
getting-
prayer-
Provisional pension I'm getting.
If we
Ah.
go by the prayer, Your Lordship, he is
Your
asking
your
for
prayer is what?
retire benefit.
Starting is that order, my lord, whereby appointing officer and the
No, Your Lordship, that is not there.
There is a is it
His prayer is on page number 10. Your Lordship.
Setting aside the order dated 3/6. What is this 3/6?
that is the appointment of inquiry officer and the provisional officer.
Why?
This
My lord,
is-
Just for the sake of it. Why you are challenging that? Where's 3/6? 3/6 is where?
page number
Page
15.
15, my lord.
Huh?
Page 15, my lord, annexure 2.
815, yes. Why you are challenging that?
My lord, thereafter nothing has been done, my lord. Just
So?
in the name of
So
discipline.
can you challenge that for that? You are not
So-
challenging the disciplinary proceedings.
My lord, actually, initially I was not getting my provisional pension also.
Now you have got it.
Lordship, lord.
Fantastic. Now you should be happy with that. Now we have nothing to do here now. The challenge of 3rd of June has no meaning. Should we direct them to dispose of the departmental proceedings as early, which may not be in your interest? So you don't, I think better off, as you are getting the provisional pension, nothing remains. Don't go on this 3/6 any further. Withdraw as you are getting. I'll record that you are getting the provisional pension, and as such you not like to press.
Lordship, lord.
I think that is a better option,
Lordship, lord.
because otherwise I'll have to direct them to complete it, which may not be in your interest.
My lord. Actually, on just yesterday, it was confirmed that the provisional pension is getting about.
Your name?
Each on the
Heard Mr. B. Chandra, the learned counsel appearing on behalf of the petitioner, and Mr. D. Bora, the learned counsel appearing on behalf of the
Respond numbers 2, 3, 4, 5, 6, and 7.
6 and 7. You are appearing? Mr. S. Datta appears for response number 1. The learned counsel for the petitioner submits that though there is a challenge to the communication dated 3/6/2022, whereby an inquiry officer as well as the presenting officer was appointed in terms with the provisions of the Assam Discipline and Appeal Rules, Assam Services Discipline and Appeal Rules 1964. But he has instruction not to press the said challenge to the communication dated to the office order dated 3/6/2022. I go to office order. The learned counsel further submits that pursuant to the order passed by this court on 23/2023, the petitioner is now receiving the provisional pension. Mr. D. Bora, the learned counsel appearing on behalf of the respondents, further submitted that the petitioner is presently being paid the provisional pension. However, the final pension could not be processed due to the pending departmental proceedings and the submission of the charge sheet in the Voca PS case number 43/2022 under section 120B/384/409/420, which has been subsequently transferred to the Vigilance and Anti-Corruption Assam. In that regard, he has placed on record an instruction as well as the order dated 12/5/2023 issued by the ADC in charge Hosai subdivision. The same are kept on record and marked with the letter X and Y. The learned counsel appearing on behalf of the petitioner therefore submits that as the petitioner is now presently receiving the provisional pension, he would not like to press the instant petition. He, however, submits that non-pressing of the instant petition should not prejudice the petitioner in the departmental proceedings as well as also in his claim as regards the final pension. Taking into account the above, this court closes the instant writ petition on withdrawal. It is made clear that the withdrawal of the instant writ petition shall not prejudice the petitioner in the departmental proceedings as well as also for the right in respect to the final pension.
Liberty, there is the display posting.
Eh?
I am with Liberty. There is the display posting.
Why?
Liberty.
You have already challenged, nothing is there. 48. Yes.
Please, Your Lordship, I received the instruction.
Fixing the matter in quick succession, in fact, helped. Get instructions. So cause has been given.
Lordship.
Focus after my lord.
Yeah. You've got the show cause. 12th of May. Long time back. To show cause under rule 9 of the Iman rate with so and so, why any of the penalties prescribed in rule 9 should not be. While you were working as pioneer, you are therefore charged with misconduct for not informing your arrest by the court in your arrest and charged with heinous crime. Yes, then what it means?
After 9 years, my lord. So cause has been given after 9 years.
So?
And I have informed regarding my arrest, my lord.
Mm.
In the year 2014 only.
Mm.
Case 33.
Mm.
My representation, my lord.
Understood. That is your defense. You have been suspended since when?
2014, my lord.
Then what were you doing all along sleeping?
No, my lord, I have represented the deputy authority.
Understood. Why you didn't approach the court?
There is a delay in approaching the.
But once the show cause is given, how can this court hold anything else now? You submit your written statement, then you can't be, you have to be remain under suspension. Okay.
My lord, they are also waiting for last 9 years.
I can only say for early disposal of the year, which may not be in your interest.
That is them, but this proposal otherwise not serve their purpose also, my lord.
Their purpose is not that. Then if they doesn't serve, so let them what you call decide. Should I direct that to do it within a period of 6 months?
I am not praying for that, my lord.
That's the problem arises. Because you're right. On Ajay Chaudhary goes with this document.
May I pray that madam will be taken after vacation, my lord.
Why? This court is also again sitting in this bench only. They won't tell you.
No, my lord, I'm not saying that, my lord.
No, there's no way out.
Maybe, my lord, during vacation I can find out something.
You can't find anything. Ajay Chaudhary has been taken right, left, and center everywhere. The amount of judgments I've given on Ajay Chaudhary.
I have seen, my lord.
In fact, in the last judgment of Prasanto Datto, I have also dealt with Ajay Chaudhary in detail. How, when, what will happen.
Madam, may take it after vacation so that I can have an opportunity to go to it, my lord. Prasanto Datto.
Okay. Heard, Mr. NJ Khatunia, the learned counsel appearing on behalf of the petitioner. Miss R.S. Longkang.
S can
Huh?
S can press.
Oh, yes. The learned counsel appearing on behalf of the respondent number 1, 2, 4, and 5 submits that the petitioner was served the memorandum of charge as well as oblique the charge sheet on 12/5/2023. In that regard, she has placed before this court the said memorandum of charge dated 12/5/2023, which is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner seeks for an accommodation in that regard. List the matter after 4 weeks.
49.
Your Lordship, placed one letter from the DC.
Yes, why did you do it?
Some more time is required, Your Lordship. At least 1 week time.
And I request you to move the Panchayat. Mr. R.K. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. T. Bora appears on behalf of the respondent numbers
Respondent numbers, Your Lordship, 2 and 3.
2 and 3, and Mr. S. Doctor appears for respondent number 1. The learned counsel appearing on behalf of the respondent number 2 and 3 submits that he requires further time to obtain instruction in terms with the order dated 26/6/2023. Taking into account that the matter be listed again on 26/7/2023. Because the interim order passed earlier shall continue till then. The communication, the instructions were placed by Mr. Bora is kept on record and marked with the letter X.
And number 8 for admission.
Who kill you?
Lordship, may kindly take it up after the
Vacation, na?
Lordship.
Okay, after vacation.
Applaud.
Oh, that transport.
My lord, ASTC pension matter.
Ah.
On last occasion, Lordship has directed the pension department to file an affidavit, my lord.
Then what happened? Has the pension department filed?
No, not yet, my lord.
They won't file. Where is the pension? Pension was very much here. Claims benefit of pension under the aforesaid subsequently yet another memorandum was issued whereby it was provided that matter needs and not filed. This memorandum. Yes, pension. Mr. Goswami was appearing on the last occasion.
I'll just call him. Your Lordship.
Yes, Mr. Goswami. You have not filed affidavit, why?
Lordship, affidavit ready, Lordship, for it's sent for vetting. Ready. Affidavit ready. A file for it is sent for vetting.
Mr. P.K. Kulkar, the learned senior counsel, assisted by Mr. A.R. Borua. Mr. J.K. Goswami appears on behalf of the pension and director of pension, who submits that the affidavit is ready and will be filed within 7 days from today. List the matter on, yes, when?
Vacation.
Obviously, when? List the matter again on 7th of August 2023. Ms. M.D. Bora appears for the transport department and Mr. C.R. Sharma. C. Sharma appears for the transport. Yes.
Okay.
12. Okay, 12 pwede. Yes, Mr. Khan.
This matter is pertaining to pension lottery.
Huh?
Pension and other service benefit.
Then this court is taking up pension matters only.
But despite of the interim order lottery,
Hmm.
they are not providing also the provisional pension.
What? What is wrong? Where is the order? Yes.
20.
Yes, madam, tell me.
Lordship, we have received instruction.
What about provisional pension?
Lordship, department has sanctioned leave encashment benefit on 22/8/22. And he is not, and so Lordship.
What about provisional pension? There is an order passed by this court. May I ask the commissioner to appear? There is a director of Panchayat also, na?
Lordship, we have received some instructions from the commissioner, but
What is
Well-
that? What about the provisional pension? Why it has not been done?
he is not entitled to the pension because he is regularized after 1st February 2005.
Okay, then it is. You have been regularized.
Past service would be countable for the purpose of lordship pensionary benefit.
Irrigation department.
That is a lordship settled
Where?
the lordship regarding the past service.
Oh.
I joined in service lordship in the year 1996
For what? Under
uh,
what? As a?
as a temporary employee. Lordship.
Then how do you bring those service out there?
And so I was appointed again the village center with a scale of pay. And
You were getting a scale of pay.
I got a scale of pay. Subsequently, 1/6/2013 lordship, my service was regular. And I retired from service in the year 2021. Lordship, that I worked as a temporary employee for the year, 17 years, 17 days. And as a regular employee, 7 years, 9 months, 30 days. Total lordship.
Have you made the finance department a party?
Yes, lordship.
Where's the finance? But this is a very important question which is going on.
Right.
See, you have the latest copy of the year, GLR, the latest issue, the GLR.
I got latest issue of DLT is there.
No,
There-
not
there is-
LT, DLR. This is a judgment of justice of the division bench
Yes, lordship. In this
of which have been written by Justice Adak Ete.
this is the case by the Honorable Chief Justice and Italy.
No. By Justice Adak Ete. It's a very recent judgment on the issue which is similar as regards the service book and all. No, why I'm saying is now you see there's a big problem which your finance is going to face.
Lordship.
On one hand, in master role workers, PWD, which I am telling you, most of the master role workers that were appointed were regularized on 22/7/2005 on the basis of an order passed on 30/10/2005. Okay. Now they are being given on the basis of Sanchita Roy.
Qualifying service. Yes.
On some other cases also they are being given. Now, if they are regularized on 22/7/2005, and you are giving the benefit of that in those people, why not here?
Here, there was a decision. Finance department, so far as the master workers are concerned, a notification was issued pursuant to the decision of the department. That they will come under the old pension scheme. There is a notification to that.
When?
I don't remember the date, but it is there.
You kindly
And
get
following that, my lord, those stipendary teacher, my lord,
Ah.
they were, my lord, given the same benefit that since they have been regularized subsequent to, my lord, February 2005. Following this, my lord, decision of, in case of master worker, they were also given. There is a notification to that. Only I found these two, my lord, exceptional cases. One is, my lord, those
No,
stipendary teachers.
stipendary teachers get it on the basis thereof.
No,
without
there was
the-
a direction of this honorable court to
That
consider
is a
that,
different thing.
But
There,
here, master,
there
my
might be
lord,
direction, but the fact that the stipendary teachers were appointed on the basis of a selection and on the basis of that service code 1981 conduct rules, they are entitled to.
that
Irrespective of that, also by virtue of these two, they are entitled.
master worker, my lord, there is a
But
notification.
master
I can-
workers is this.
I have got to annex that case 79.
Yes, it is here.
That office member.
Yes, yes, it is here, one.
Page 79.
79.
This is
2009.
9.
9 June 2000. Workers and master role worker shall not be governed by the new pension, but may be treated as per existing service good pension. Similar such cases, if any, may be entertained after obtaining the views of concerned department, including finance department and approval of the secretary of the concerned. I serve without any break, continuously I serve.
No, you see that judgment, which I am telling you.
My lord, I have brought one report, the latest 2023 judgment. Relying that judgment, you lost it.
Which one? The Uday Pratap Singh,
Yes, Lord.
the Uday Pratap Thakur,
Yes,
by Justice M.R. Shah.
yes, Lord.
No, that I know. But that was on a, that has to be read along with, there was a rule out there in I think, Uttar Pradesh, na? UP or where?
Bihar.
Huh?
Bihar.
Bihar. There's a rule out there whereby the past service would be taken into consideration for the purpose of giving the benefit for having the qualifying service. There was a rule.
Yes.
That rule was challenged. And when that rule was challenged, the Supreme Court said that no, that is okay. But because you can't be equated with a person who normally properly passes and gets appointed. With a regular one, you can't be equated. But it is also a fact that these people concerned cannot also be said that after regularization, they would not be entitled to because they don't have qualified. So much of the service was asked to be taken till they attain the qualifying service.
Qualified.
That is that, isn't it?
Right.
Now, you see, for the purpose of master role, I have applied their judgment to many cases, but there you apply it to master role, taking into account the office memorandum of 31/7/2010.
28.
Huh?
28.
No. Earlier service. You see,
Yes, past service.
this judgment you have to apply. How do you apply? You apply for master role with that thing. That office memorandum of 31/7/2010.
Past service, my lord, as a master role.
For that. Now here also, but Mr. Khan, your case is directly covered by that division bench judgment. Chief Justice and Justice Kartak Ete. He has written that judgment.
That is GLR.
The last GLR. Hey, yesterday or day before they give us this fact book. Yes, there you get that judgment, which is directly covers the issue. Okay, after vacation. Mr. M. Khan, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the Finance Department. Ms. Mbora appears on behalf of the Corporation Department.
PNR.
PNRD.
The Corporation Department here.
Last quarter, wrongly. Working department.
Appears on behalf of the PNRD.
Respondent number
Department.
1, 3, 4, and 8.
Appears on behalf of the respondent number 1, 3, 4, and 8. And so The learned counsel appearing on behalf of the petitioner submits that he may be granted some opportunity for which let the matter be listed immediately after the vacation on 24th of July. You get that, Judge?
My lord,
Huh?
I
Yes.
apply.
I never thought that that judgment would be required today. I didn't bring it, but that 13
Directed file on the last day. it
don't
is due.
require the affidavit. The respondents are at liberty to file their affidavit on a report.
May please your lordship.
Yes, suspension.
Lordship. During pendency of this petition,
What have you done?
petitioner is reinstated. Lordship.
My lord, the petition
Reinstated?
has been reinstated, my lord.
But
By
effect was
following the
given
judgment of
wrongly.
Azad Chaudhary, my lord, we have reinstated him, my lord. And as per the earlier order, my lord, we have also released 75% substance allowance. My lord.
But effect was given wrongly there, Lordship. Petition, Lordship, kindly take up affidavit dated 16/6/23, Lord. We have filed.
Whose affidavit?
We have filed, Lord.
Yes, what is that?
Page 57, Lordship.
Huh?
Page 57.
50?
7, Lord.
57, yes.
Last line, Lordship. And the suspension order number so and so is revoked and reinstated and regularized his service with effect from 12/5/23. The petitioner was suspended by the order dated 37/22. Lord. Page 37 to the petition.
Yes, what do you mean by that?
My lord, I have not received a copy of this affidavit, my lord. So I-
You
Yes.
no. You say that he has been reinstated.
Yes, my lord.
So you have that order.
I don't have this order, my lord.
Give it to him.
My lord, in this case, my lord, DP is still pending, my lord, for final consideration, my lord. And regarding
Okay,
this,
that's okay.
yes, date of effect, my lord, it ought to have been, my lord, 31st October, my lord, after expiry of 90 days by following the Azad Chaudhary judgment, because we did not review the suspension, my lord. That is why, my lord, the instruction was that, my lord, they will comply with the Azad Chaudhary judgment, they will reinstate him. My lord. Probably, my lord, date of effect perhaps may be wrong, my lord.
He's revoked and reinstated and regularized his service with effect from 12/5/2023.
Yes, my lord. He was suspended on 30 July 2022. So basically, my lord, 90 days will expire on 30th October, my lord, 31st October 2022, my lord. So, my lord, since we did not extend that suspension, my lord, we did not review that suspension. So applying Azad Chaudhary, my lord. So date of reinstatement will probably, my lord, 30 October, my lord, 2022, my lord. So this date,
No, the reinstatement will be the date on which you reinstate.
yes, my lord.
You are not reinstated from that date.
No, my lord. It's
So,
all,
the
yes.
reinstatement will
Yes.
be this. This will be the period within which he has
Yes.
to be taken into account and he will be entitled to the subsistence allowance.
Yes.
What is wrong, madam, with this order?
Reinstatement.
Your reinstatement can't go back to that date.
From the date of where I
No.
filed order dated 37/22.
Madam, the reinstatement will be only from that date on which you are reinstated. That period of suspension may be treated at a particular point of time that as on duty or not. First one, that will be subject to the outcome of the departmental proceedings as to whether to keep it as on duty or not. If you are on duty, you get the entire thing. If you are not on duty, then it is on a because you can't get it before that, na? You are reinstated only on this date. 12/5.
Yes.
So from there only it will start your reinstatement. The regularization, the earlier period you will be put under suspension, but for that you have got the subsidy. If we now give it back to that date,
Subsistence allowance up to 75% has been given. No, but, my contention before your lordship is this, subject to correction by your lordship, that I was suspended with effect from 37/2022. No, my lord, in that case, when I am reinstated, suspension is cancelled.
no,
And that should be
Suspension is not cancelled. The period of suspension will remain as it is.
Yes, madam.
You are there. For that, you have got 75%.
Yes, madam.
Now, they have to pass out subsequently an order. If there is a pending departmental proceeding, they have to pass an order on this aspect. What is to be done for that?
From suspension to this order.
That should be treated as on duty or not. The moment it is passed as on duty, then you will be entitled to the area salary of 25% for the entire. Because now if we go back to that, you will be entitled to the area salary.
Yes. Yes.
You can't be entitled now. That will be subject to the departmental proceedings.
Departmental proceeding is over.
So nothing remains now.
My lord,
I will do one thing, Mr. Sheikh.
my lord.
I will record the order about your contention. I will say that the department shall duly take note of at the time of deciding the departmental proceedings.
Right.
So that clarity remains at the time of departmental proceedings, this period of suspension to be made, the question, the period of suspension as to how it is to be treated. Because there are many cases you must have seen. Some are treated for the purpose of that period as dice non. Some are taken as that period for the purpose that they are on duty. Sometimes these are all at the time of final outcome of the departmental proceedings. So nothing remains. Heard Mr. M.A. Sheikh. You are there, Mr. Sheikh?
My lord, yes.
M.A. Sheikh, the learned counsel appearing on behalf of the petitioner.
Yes, that's my lord for 2, 3, 4.
Mr.
Yes, that's.
S. Das appears for the respondent number 2, 3, and 4, and Mr.
N Kalita for respondent number 1.
N. Kolita appears for the respondent number 1. The learned counsel appearing on behalf of the petitioner had submitted that pursuant to the order dated 27/3/2023, on 12/5/2023, pursuant to the order passed by this court on 27/3/2023, the Managing Director of ASIDC Limited had passed an order on 12/5/2023, whereby the petitioner has been reinstated and during this period, and during the period of his suspension, for the first 3 months, he was paid 50% of his 50% subsistence allowance. And he was paid subsistence allowance at the rate of 50%. And after 30/10/2022, he was paid 75% of the subsistence allowance. Subsistence allowance at the rate of 75% per month. Mr. M.A. Sheikh, the learned counsel, however, apprehends that as the petitioner's service have been regularized only with effect from 12/5/2023, and this order, if it remains, may affect the petitioner's right in the event the departmental proceedings is decided in favor of the petitioner to the full salary during the period of suspension. He, however, submits that as the petitioner have already received his subsistence allowance and have been reinstated, there is no, the instant case otherwise have become infructuous, save and except the clarification which this court may be pleased to give in that regard. Upon hearing the learned counsel, this court and hearing the learned counsels and also taking note of the order dated 12/5/2023, this court is of the opinion that nothing survives in the instant writ petition, taking into account that the petitioner had already been reinstated and the petitioner also received the subsistence allowance in terms with FR 53 of the FR and SR applicable to the state of Assam. This court further would like to clarify that the period of suspension, as to how the period of suspension is to be treated, shall be subject to the outcome of the departmental proceedings, which the disciplinary authority shall duly take note of at the time of finalization of the disciplinary proceedings. Department.
Highly organized.
15,
Argumenters say. Yes.
But here an affidavit has been filed, my lord.
Oh, you want time?
File a short if not.
Okay. Mr. M.A. Take, the learned counsel submits that he requires some time for filing a reply to the affidavit in opposition.
Yes.
To list the matter after the summer vacations. In the meantime, the affidavit may be filed.
18,
Chalo. Okay, none appears on behalf of the parties. List the matter after summer vacations.
21,
Lords, record not received.
Eh?
Record not received.
What record?
It will be the departmental proceedings, Lordship, and directed to produce the records along.
Departmental proceedings is over.
No, it is transfer matter, Lordship.
So no stay.
Stay is
There's
there.
a stay as per the order
Stay is
dated 12/22.
Then
Uh,
transfer from where to where?
Your Lordship, the first transfer is from Lakua ICTS project to Juria.
Yes, 1 minute. Where is that order?
Your Lordship, page number 14.
Page number
14, an extra one, your Lordship.
14. In the interest of public service, so and so is hereby transferred and posted in the office of the child development of the Juria. Oh. See, Juria has a lot of problems.
yes,
Huh? Against vacant post in the same capacity and pay. And from where is he transferred?
Then from Juria, your Lordship, he was transferred to Rupahi. That is the second transfer in an extra page number.
Oh, that is on 2nd of May and 10th of May.
Yes.
But distance between two places, Lordship.
Wait. What is his name? Petitioner's name?
Vahidutam.
Wahidur Rama. Let us see. He was transferred from Juria to Iman. Then from Juria to Rupuhi. And who has been put in Juria? Nobody.
Oh, your Lordship.
Huh? So what is your problem going to Juria or Rupuhi?
No, your Lordship, on 10th of May, he was transferred from Juria to Rupahi, which is an extra page number 15.
In partial modification of the earlier order dated so and so issued against Wazidur Rahman Sene is hereby cancelled. Directed to join Juria. Then
Then on 7th, within a month, he was transferred back to Juria from Rupahi.
Madam, tell me one thing. On 2nd of May 2022, you were brought to Juria.
Yes.
Okay. 10th of May, you have been brought from Juria to Rupohi.
Yes. And
And that was cancelled on 7th of
7th.
June.
So, this is the improvement of
7th of June is the impugn order. So,
your Lordship. If your Lordship,
where do you want to stay?
Your Lordship,
Juria.
Rupahi.
Why?
between half kilometer, it is 30 minutes distance. Lordship.
Why? Now you have any affection towards that particular place?
Your Lordship,
Isn't it too early to have an affection when you have been only there for 1 month?
it is in violation of the OM, your Lordship.
What way?
OM of 2002, your Lordship.
For 2 years.
Your Lordship.
If you are going by that, then this is also violation of the OM on 2nd of May and 10th of May.
Your Lordship, no reasons have been assigned for my.
Why reasons are to be assigned? Do you want them do we also have a, do you appoint district judges or some person from the judicial academy for the purpose of passing transfer orders so that they can pass reasoned orders?
On the last occasion, Your Lordship, there was produced the
Last occasion that lordship was very clear, very considerate enough. This court is not at all. How can you apply that? On one hand, you say that apply office memorandum. If you apply that office memorandum, your transfer to Julia becomes, Rupohi becomes bad. Isn't it before 2 years?
Lordship, within a month they have transferred.
Understood, but earlier? Isn't it? Then how do you apply? For selectively you will apply. Can you do that? Well,
Produces next to 5 pages. Page
Page 20 is what?
20 of this,
Page?
20 and next to 5. That is the type shop.
I know that this is 2 years. Isn't it?
Lordship, no proper justification has been given for my.
So where is the justification earlier to be transferred to Rupohi? Tell me, where is the justification? When it helps you, you know office memorandum. When it does not, office memorandum. Tell me, give me a good justification for that.
If they produce the records.
Huh?
If they produce the records.
Records not.
Forget about his records. I don't ask the respondents unnecessarily. Whenever it's necessary, I don't ask the petitioner. You forget about his records. But tell me, what is their records going to help you? If they have to just transfer it. Where is your senior?
He's in Nagaland.
Huh?
He's in Nagaland.
Nagaland. Fantastic. Now you have no one to help you. Transfer order has to go. You have to go. The interim order has to be vacated.
Make it after it.
No, dismiss it now.
But may hear my senior.
Why? Transfer matter. This court doesn't have the jurisdiction, it's limited jurisdiction. Tell me. Chalo, your senior is not there. If your senior would have been there, I would not have extended. I would have dismissed today. Because of your senior is not there, you have got an extension. Here's your name. S. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the
All the
respondents. Mr. Goswami submits that he requires some more time to obtain the necessary instructions as sought for by the order dated 12/6/2023. List the matter again on 24th of July 2000, on which date the learned counsel appearing on behalf of the respondent shall produce the records on the basis of which the order dated 7/6/2023 was issued. The interim order passed earlier shall continue till the next date. Tell your senior, because of you, this order has been given.
And about 30
Not
to
because of your senior.
43. 30 to 43.
Yes, where should the money go?
My lord, I have got the information from the Commissioner of Taxes. They have stated that, my lord, it will be appropriate if, my lord, money, so far as the refund part is concerned, is deposited in a consumer welfare fund prepared by the, my lord, Agriculture Department.
Why?
In tax matters, my lord, it's like that. Even in GST, there is a consumer, my lord, welfare fund where such monies are kept. Those are used for the benefit of the consumer. There's a agricultural consumer, it will be for their benefit. Or as Lordship may, as part of judgment, Lordship will, my lord, give a direction to the Honorable Chief Minister to have a call in this regard.
Hello.
Either way, my lord.
I'll dictate in the court itself, not today, last day. That won't be proper. Let me have it on 28th of July 20.
Lordship, if not 30th July, if it can be on 21st also.
Not 21st. 21st, you see, at the end of the day, how do you finish it?
25th, Lordship, Tuesday. 25th.
Okay. It's the matter again on 25th of July for further consideration.
Okay, only one consideration if Lordship would have
Yeah.
given. That I have no objection, Lordship. We would have prepared the CA certificate also, but Lordship, I have asked my client, they don't need a refund. But Lordship, for harassment and all the expenses which we have incurred in the legal, only Lordship 10% or 5% also if that if they have been refunded. That is my only prayer before Lordship, that may be considered by it.
For what? For filing cases?
No, Lordship, refund. Yes, Your Lordship, of the refund. 5% of the amount.
Ask your client why, because of them, so many people have been used. How many trees have been destroyed because of your client? What do you do about forest, about the environment?
If this money could have gone into environment, something that would
That
be
is
very
why the money should in fact go to the environment
Fine.
because of
Yes,
filing of such bulky writ petitions. Don't you think that? Huh, Mr. Gogoi? It should go to the environment.
Yeah.
Because of them, such bulky petitions have come. So many must have finished.
Yeah. And there is a series to not only one petition.
Yeah, that is what so much of people. This should go to the environment ministry. Better of
cancer lossy hospital or environment.
cancer and cancer. Other things will happen nowadays. Medical has a lot of money, but for environment, this is required because what you have done with so much of wastage of papers.
Only for Lordship considering 5% only for all the Lordship trouble which have the petitioner have taken. Lordship, I'll just leave it to the Lordship.
Let us hear again on 25th. 46. I'll pass the order on that day.
Yes.
Then I will come. 46. Okay. Yes.
Highly obliged.
May I please, Your Lordship?
Tell me.
Can you schedule the order dated 26, 2020?
After detail, yes, it's a very serious thing which you have done, Mr.
Your Lordship, we have received the instruction, Your Lordship. Your Lordship, the department will, of course, comply with the direction given in the earlier petition, Your Lordship. Some more time is required.
For what?
For completing all the process.
What process?
Your Lordship, me kindly.
What you have completed? What you have given?
Your Lordship, the contention is that in the petition
shall indicate by way of an affidavit as to why the petition have not been worked out till date in terms with the directions stated so and so. You have worked out?
Your Lordship,
that is the only thing which is left. Yes. And if you are saying that it has been done, then what is there?
That is not completed, Your
So
Lordship.
you have not done it. So we call the person concerned.
No, Your Lordship.
Who is that? Commissioner?
Your Lordship,
No, Mr. Kumar. This is not done. This court made a very serious thing. This has nothing to do. It's a very serious thing we have to take note of.
Your Lordship,
When, who is that person who is the commissioner and secretary? Exemplary cost.
Your Lordship, kindly one more chance may be given, Your Lordship. After vacation, Your Lordship, 1 month time, mate.
Okay, cost of 1 lakh. No, this is exemplary. I use the word constraint to impose exemplary cost upon the commissioner and secretary to the Department of PNRD. So upon the commissioner and secretary, 1 lakh is to be taken from his account, from his salary, and deposited in the benevolent fund, lawyers benevolent fund.
Lordship, thing is that, Your Lordship, in the earlier petition, Your Lordship.
No, Mr. Kaul, this is serious.
Yes, definitely.
This is absolutely
I
serious. No,
absolutely agree with you.
I have no. Today you have not got your instructions. So under such relevant instructions are not there. Imposition of cost of minimum 1 lakh or 2 lakhs is the question. What is the salary? 1 month salary has to be taken. 1 month his salary from his bank. Heard, Mr.
Your Lordship, kindly.
This is not relevant. No, you have not done that. The specific direction was.
It is under process. Your
No, it can't be under process for 7 months.
Your Lordship.
That was the first direction passed by this court. Was clear. The direction passed on 24.
Yes.
This court, after taking into consideration the respective submissions made by the learned counsel, disposed of the same with the following. In view of the above, the petitioner is entitled to fund the entire length of service for pension and other pensioner, and the authorities will work out the entitlement of the pension and discharge and accordingly issue fresh orders in supersession of the earlier orders passed by the authorities, which exercise shall be undertaken by respondents within a period of 2 months from today. The aforesaid amount will bear an interest at the rate of 6% per annum. Now tell me, this is an order which has attained finality.
Yes, Your Lordship.
After having attained finality,
Yes, sir.
because of your office delay, isn't it the public money which is being spent?
No, Your Lordship. He's entitled.
No. The interest, isn't
Yes,
it on the public money?
Yes, definitely.
Then, shouldn't it be that interest shouldn't go from the commissioner's pocket? Let him pay. Apart from the above, the cost of 2 lakhs which this court is imposing, you have to pay the interest also from your pocket. Mr. Gogoi, what could be done? How it is to be deducted from his salary? Give me a way. This is serious, sir. The salary. No, that is salary will only happen, but this amount will go up. 2 lakhs is for the purpose of cost. Then from salary, the interest, because you see, this order was passed by this court in 2019 with an interest of 6%. Why should the public money be spent because of your inefficiency of your commissioner, Mr. Counsel?
Your Lordship, so far as the commissioner is concerned, he has done his part. Your Lordship.
What has he done?
He has forwarded to the government. Your Lordship.
Show me that. What he has done. Is the commissioner and PNRD is not the government?
Your Lordship,
The director, it's a level of director. There they need to call it commission.
No. This court had said commissioner and secretary to the Department of PNRD.
Your Lordship, at that time, that post was there. Your Lordship, now the director is designated as a commissioner.
I am not concerned with
Secretary.
those commissioner. I am saying about do you have a commissioner and secretary to the Department of PNRD?
Not as of now, no such post is there. Your Lordship.
What post is there?
Commissioner post is the director, and the secretary post is separate. Different.
So there is a secretary.
Secretary, principal secretary.
Okay. Principal secretary is there.
Yes.
We fix it on 17. Ask him to appear before this court at 10:30.
The principal secretary. Principal secretary or secretary?
Principal. He should be present. And we should, I will ask him and ask him also to put it on affidavit as to why interest should not be imposed, why the interest for this period from pursuant to the judgment of this court, how is he going to pay? without affecting the public money. Because of his lapses, this has happened. Heard, Mr.
I'm appearing on behalf of R. Purvar.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. K. Kaur, the learned counsel appears on behalf of the respondent number 1, 4, and 6.
Yes.
First, this court by an order dated 28/6, by the detailed order dated 16/12/2022 had directed the respondents, and more particularly the respondent number 1, 4, and 6, to indicate by way of an affidavit as to why the petitioner's family pension has not been worked out till date in terms with the direction passed by this court on 3/4/2019 in WPC number 2226/2019. The matter thereupon was listed on 12/6/2023, on which date the learned counsel appearing on behalf of the PNRD again sought for instructions. The matter was again listed on 28/6/2023, on which date also there was no instructions available. And this court had made it clear that if relevant instructions are not placed before this court would be constrained to impose exemplary cost upon the commissioner and secretary to the Department of PNRD. Mr. K. Kaur, the learned counsel appearing on behalf of the PNRD department, submits that there is no post of commissioner and secretary to the Department of PNRD. He submits that the director level officers are known as the commissioners in the PNRD department, and there is a secretary as well as a principal secretary in the said department, of the said department.
Your Lordship, it is not that the petitioner has not receiving any family pen.
I am not concerned with all this. There is a direction. Have you complied with it?
Yes. Yes.
This court further finds it relevant to note that not only any affidavit has been filed as directed by this court on 16/12/2022, there is no instruction placed before this court relevant to the issue, in spite of various orders being passed by this court. The action of the respondents, more particularly in the PNRD department, prima facie shows willful and deliberate defiance to the order passed by this court on 3/4/2019 in WPC number 2226/2019, as well as the other orders passed by this court from time to time. Under such circumstances, this court fixes the matter again on 17th of July 2023 at 10:30 a.m. On which date the commissioner, let it be on 19th, on which date the commissioner, the secretary to the government, to the Department of PNRD shall be personally present at 10:30 a.m. This court further finds it relevant to note, observe and direct that the secretary PNRD of the PNRD department shall explain why there has been non-compliance to the order dated 3/4/2019 in WPC number 2226/2019 till date, and also explain as to why the interests which have been imposed in the order dated 3/4/2019 at the rate of 6%. Now, why the delay in compliance with the order dated 3/4/2019, which would entail an interest at the rate of 6%. Thereby affecting the public revenue, should not be deducted from his salary.
Oblige it. Your lordship, a copy of this order may kindly be provided.
Mr. K. Kaur is directed to apprise the secretary to the Department of PNRD, to the PNRD department, the order so passed hearing.
Oblige.